you. Can you hear me?
I can, yes.
Great, fantastic. Sorry for the late start, you guys. As I think most of you know, my husband and I moved. It was 3 days of moving, and we're moved in. If by moved in you mean the furniture and the boxes are in fact in the house. Other than that, we're not moved in at all because everything is sitting around in boxes. So, but we're getting there, slow but sure. And so it's going to be weeks before everything is actually unpacked and put away, but we're safely ensconced in the new place. So I sent Kingmaker a message too, so he should be joining us here hopefully. Ship, what are you doing? You sound like a mouth breather.
Yeah, I'm trying to get a window open
Oh,
that one of my kids closed on me, and it's not wanting to cooperate. Hang on.
okay. All right, so he's muted himself while he deals with his window situation. I'm here tonight. I've got my husband here, Steve, with me. As I think most of y'all know, he's a lawyer, also a longtime lawyer, practicing law 50 years at this point, and has argued twice in the Supreme Court, argued in most of the circuits, so he's very knowledgeable appellate law wise. All right, King is requesting, so let me add him as a co host. King, I just sent you the co host invitation. Hopefully that lets you click in. And then we can get started. Hopefully Ship's getting his window situation straightened out.
Done.
Fantastic. All right. King, shows me you're a listener. Oh, now you're the co-host. King, can you hear us?
I'm here, loud and clear.
Fantastic. How are you tonight?
I'm very well, thank you.
Good. Good, good. All right, so I think we're ready to go. All right, guys, so we're starting a little bit late. Again, I apologize for that. And we'll go as long as we need to, but hopefully not too long tonight, because I think the big show is, as Ed Sullivan used to say, is going to be tomorrow. But we do have some very interesting things to discuss tonight. So there were some cases that I think really caught people's attention for the right reasons for those of us who are right of center, and then some smaller ones that people maybe didn't notice as much that I also would like to mention so that people understand what's going on. Because have viewed the last 2 weeks of the court's decisions as being just tremendous wins for the cause of liberty, for the cause of the rule of law, for the cause of if you ever find yourself having to defend yourself from the United States government, good rulings. But some of them, are sexier than others in terms of what the media plays up. Some of them are more technical things that only maybe defense lawyers or prosecutors would appreciate, but I think they still are important and people should know about them. So, shall we start with the big case, Ship? You want to start with the January 6th, 1512 decision?
Sure. Obviously, I've lived with this subject matter for the better part of almost 3 years. I think I argued my first motion to dismiss along the lines of the rationale argued in the Supreme Court in October of 2021. I probably argued it at least 8 or 10 times after that. What eventually happened was every judge was sort of on record. So, you knew you would make the motion pro forma, just so you made a record that you moved to dismiss. But, after the first 8 or 10 months, every judge had ruled, and only Judge Nichols had broken with the pack and dismissed the count on the rationale offered.
Okay,
So
by
then,
every judge, you mean every judge in the U.S. District Court in D.C.?
yes, so I had counted it at one time. I think it was 17. Now, a couple of judges have been added to the court since this all started. They have, I don't even know, but I'm going to just guess they fell in line with the others or held off actually making a ruling, knowing that Fisher was pending. So we've all been waiting, on this decision. I think, retracing just a bit of history might be worthwhile. I mean, I got to kind of assume that not everybody knows the background as
Yeah.
well as I do, so let me go through it a little bit. Um, the motion to dismiss is the 1512 C2 count, which involves just a phrase that says, if an individual otherwise corruptly obstructed an official proceeding, that was a crime and subject to a 20-year sentence. Now, that phrase in isolation has almost no meaning. But what the government was attracted to was the 20-year statutory maximum sentence under circumstances where, and I've written a little bit about this, there weren't a lot of real good alternatives if they
Right.
wanted to get something other than a glorified slap on the wrist.
Right.
So,
There are a lot of misdemeanors that could potentially apply to what happened on January 6th. And you've got the civil disorder statute
right.
and assault,
And
you
what
know.
you had, and where they had good evidence of actual physical violence, interaction with the police, that sort of, that carried those cases because there's so much video. It's not hard for them to document it once they identified. But that left, hundreds of other individuals who they wanted to focus on for one reason or another, um, without a really meaningful charge to give them. While the 231 count, civil disorder, is a felony, and it is, a felony that can be relatively easily proven under the facts, the guideline range for that offense is 6 to 12 months.
Right.
So it was a charge that the government could look ahead and see there are going to be a lot of single digit or even probationary sentences
Right.
if this is the only statute we use. So they took this post Enron statute, which had never been applied outside of a document spoliation or destruction circumstance, because that's what it was adopted for, was to address a hole in the statute that was just uncovered with Enron, the Enron investigation, particularly the Arthur Andersen case, and to fill that hole. But it was written so broadly, some clever group of lawyers in the Justice Department said, "Aha, we'll just use this one and interpret it as just a dragnet for any conduct of any type or manner which obstructs an official proceeding."
Right. So let me
And
stop you there, Ship. So we agree, I think, that civil disorder statute, which is just the lawyer's way of saying a riot, right? This is what a civil disorder is. Um, that was the right statute to use under the circumstances, don't you think? Like that's the one that actually fits the conduct.
yeah, and the kind of the essential gravamen of that offense is the failure to obey lawful police commands during a civil disorder. In other
Right.
words, the police tell you to go home, they tell you to leave, quit
And you're in the
rioting.
middle of a riot. They can't tell you
Yeah,
that in general, but
and
yeah.
so you are interfering with their ability to lawfully carry out their duties by refusing to comply.
Right.
And and that has become, after the Fisher problem arose, that has become a more commonly used statute now. And what I think the government is relying on, and we'll see how this plays out, is that they're just going to try to convince the judges to vary upward in the
Right.
sentences and get out of that 6 to 12 month range and give more meaningful sentences because of the unique nature of the circumstance. But let's
And
go back to
that
Mr.
may work, but it's still not a 20-year felony
Right,
that
right,
is jacked up on the guidelines.
right. Now let's go back to how Mr. Fisher's case came to be. So one judge, Judge Nichols, he actually dismisses. It's not Fisher's case that he dismissed. It was actually a different case involving a defendant named Garrett Miller. And two lawyers did most of the, and I actually have a little bit of a window into these facts. It's kind of curious. Garrett Miller was represented by a lawyer named Clint Broden out of Dallas. And it just by a bizarre coincidence, Clint Broden and I represented two individuals who were a divorced husband and wife, both doctors. He had the husband, I had the wife, in just a crazy drug trafficking scheme. It's the most wild, unbelievable public corruption case in the history of Hawaii. I had the wife and the family business, and Clint had the husband, and I managed to keep the wife from getting indicted, and the husband got indicted. Well, when Clint was in Hawaii trying the case involving the husband, the motion to dismiss deadline came due on Garrett Miller's case. So he'd done a lot of work, and there were a group of lawyers, a group of defense lawyers who sort of been sharing our work with each other, trying to generate the best possible paperwork in filing a motion to dismiss. And the laboring oar fell to a lawyer out of New York named Nick Smith. Nick has represented several January 6 defendants, including Ethan Nordine in the main Proud Boys case. So Nick was neck deep in all this stuff, like several others of us in the fall of 2021 and spring of 2022. Nick did a lot of the final work on the brief that got filed for Garrett Miller. And lots of lawyers, me at the front of the line, stole liberally from what Nick produced in the motions that we later filed.
So
And
let me chime in here and say that from a defense lawyer's point of view, right? I had been practicing in the District of Columbia's federal court for many years, 25 years. And before January 6th happened, if you had asked me, does this obstruction statute apply to these kinds of facts? I would have just laughed. I would have said, no, of course not. You can't, stretch that Enron section in the Obstruction Act to just cover whatever you want. That's absurd. The courts are not going to go for that.
well, I'll give you a practical example. As a prosecutor, as a AUSA for 21 years, I can remember many instances where I sat down with the FBI agent to evaluate what the FBI agent thought was obstruction by a subject or a suspect or a defendant or a target. And we would go through those obstruction statutes line by line,
Right.
trying to figure out if one of them fit the facts as the agent was describing. Nobody would have, nobody, I would have never landed on that statute and said, oh,
Right.
people breaking into a building, let's use this.
Let's use that. Right. No, it's just a big no. It's just a no, that's not going to happen.
It's, the argument by the defense, which the government just wanted to wave off, and which, Justice, Barrett wanted to wave off, was this could not have been what Congress meant.
Right.
And one of the best lines in the majority opinion, and I'm kind of racing ahead, but one of the best lines in the opinion of the court was, it seems like the third subparagraph or the second paragraph of the fourth provision of a statute in the middle of 21 other sections is an odd place to drop a dragnet that basically
Right.
subsumes everything.
Covers everything, and you don't even need the rest of all of that. Right.
Right.
Well,
So,
and then can you tell us about that fish case? Because people don't know about this, but because of this fish case from a few years ago, I was sure that this statute did not apply. You know which case I'm talking about?
Yeah, that's Yates versus the United
Yates.
States. And I
Yeah.
can't say that I can recite the facts of Yates off the top of my head with any specificity, but essentially what it was is that the owners of a fishing vessel, in order to avoid being inspected and a discovery of either illegal catch or an over limit catch, decided to dump all their fish in the ocean, or some significant portion of their fish in the ocean. And then they were indicted under a similar obstruction statute, not the same one, but in similarly under an obstruction statute for obstruction by destroying records, or I can't remember
Yeah.
exactly.
Yeah.
And
No,
and
it was
essentially
like books and records and
books and
documents and
records, yeah.
whatever. And the
And
stupid, I will say this, the fucking DOJ argued all the way to the Supreme Court that fish, living animals, could be, for purposes of this statute, a record.
right, it was a
Which,
record of its own life.
right.
Its
I mean,
existence was a record of its own life,
the
of its
Supremes
being.
were like, what? What are you talking about? But that's
Yeah.
how bad they wanted to distort this statute and shoehorn these cases into obstruction, because the penalties for obstruction are much bigger.
Well, and there's another instance that sidelighted this that I had never really crystallized in my mind, but I heard Andy McCarthy talk about it on a podcast, and it was kind of like an aha moment for me. And it was okay. All this whole section of Title 18, starting with 1501, they're all called obstruction of justice. Well, who's the victim, so to speak, of obstruction of justice? The Justice Department. You're basically intruding on the work done by investigators or prosecutors. So they take it personally. And
Right.
as a result, they take
Oh yeah,
every
they get all
liberty,
kind of
every
pissed. Right.
opportunity to stretch every statute to bring within its boundaries any conduct that offends them.
That they don't like. That's
Exactly.
exactly it. Obstruction is anything they don't like. I used to tell clients this all the time. So you have to be very careful as a defense lawyer, gathering evidence, evaluating evidence, talking to witnesses, trying to track down witnesses, because even things that you have a constitutional right to do to defend your client, I have had prosecutors say to me, "Oh, well, that could be obstruction of our investigation," which is total horseshit. But that's you've laid out the test exactly. It's anything they don't like.
Yeah. So then back to Mr. Fisher's case. So Judge Nichols grants the motion
Well,
in the matter.
let me say one more thing. So, in light of that Yates case, I was fairly confident that some of the judges in the DDC would say, well, the Supreme Court's already told us we can't distort this obstruction statute all the fuck out of shape, and we're not going to do that. But then they all went and did that, except for Judge Nichols.
Well, I think they had. I mean, I think there was a little bit of groupthink at work.
A
I
little bit?
yeah. Well, no. I had this cynical view early on. I had this cynical view early on that there was some sort of collective wink and nod back in chambers behind the scenes, like we're all going to go one way, but one of us is going to go the other way, and then we're going to make the circuit tell us what is right. In other words, they purposely created a split among themselves, but not crazy. So it wasn't like 7-6 or something.
But I don't think so. I think they all bought
I don't
into
think so
this
either.
nonsense except
I don't
for
think so either.
Carl
I think
Nichols.
Yeah, I think it all came down to they kind of saw it the way um, Justice Barrett phrases it and interprets it, which is Section C1 is aimed at the evidence, and Section C2 is aimed at the proceeding itself, not the evidence of the proceeding, and that they exist in separate and independent universes of each other.
I'm growing in the view that I don't like the way she handles criminal defense cases at all.
Well, she's an academic. She's not really a practicing attorney. That my recollection. So
Right.
when justices that have never actually spent a lot of time in courtrooms answer questions, they tend to veer into the more esoteric angles rather than
Right.
no. There's a nuts and bolts process to this, and our decision making needs to reflect the nuts and bolts process.
Especially when you're talking about interpreting statutes that deal with depriving people of their liberty if
Right.
you convict them of it.
Could I say something?
Sure, sure, King.
No,
The,
Jump
the,
in here.
the,
no.
yeah, well, I'm got to. There is a sentence or two in her dissenting opinion that kind of gives her game away. What she thinks of uh, looking at statutes the way defense lawyers do. Uh, she she knocked down the idea that reading this uh, second part of the statute as a dragnet catch-all that kind of subsumes all other forms of obstruction imaginable uh, when you're dealing with a proceeding, including many already on the books. Uh, Maybe that's a little too broad and vague. She says, don't worry about that. That could be handled with a vagueness as applied argument later.
Oh, yeah, that's going to work. This is just more evidence of that she doesn't understand how, practically speaking, this stuff gets handled in court. That would never work.
Well, she seems to think it does,
Yeah,
and
well.
and 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 and, and kicking that can down the road that
Right.
way
Yeah,
is
exactly.
perfectly acceptable.
Yeah,
Yeah, well,
let's
Uh,
I know the sum
let's
total of the zero number of cases she's tried defending people.
yeah, that's a really brilliant tactic, because we'll just saddle 600 district court judges with the obligation to decide under what circumstances the statute is too vague.
Right. Yeah.
Okay, so Mr. Miller's case Judge Nichols dismisses it. He at the same time has two other pending cases with the same challenge, and that is Mr. Fisher and my friend Mr. Jake Lang. So, based on the same reasoning, he issues separate orders in each of those two cases that say, for the reasons stated in my order dated blah, 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 in United States versus Miller, the counts charging Section 1512 herein are dismissed. So now all three defendants appeal, or no, I take that back. The government appeals the dismissal to the D.C. Circuit.
Right.
And the D.C. Circuit, I believe the D.C. Circuit took up all three cases collectively. And then we have the wild D.C. Circuit opinion that creates so many more questions than it answers. That, with three opinions that go three different directions, and it is almost impossible to reconcile them to figure out, which two agreed with each other. But in effect, on the outcome was a reversal of Judge Nichols for two different reasons. The two judges that voted to reverse for different reasons, and they sent it back to Judge Nichols. Well,
we've talked about this before, but just to remind people, I think that is the worst appellate decision I have ever seen in my entire life. It is fucking incomprehensible. I don't know what the district court judges were supposed to even figure out what to do with that.
Yeah, so while I don't disagree from an incoherent standpoint that it was just impossible to work with, it probably doesn't quite rise to the level of the immunity decision out of the circuit court.
Well, no, you may be right. That one may be worse, but it hadn't come out yet. Yeah.
So okay, so then so the government, so that's going back to Judge Nichols.
Well, we should give credit, Chip, before we do, with the dissenting judge in that case. Was it Walker?
No, I think Judge Katsas had the.
Oh, Katsas had the dissent. Right. Yeah. Yes, it was Katsas. So Katsas was like, no, Nichols got it right. I don't know what the other other idiots are talking about.
His wasn't quite as narrow as Nichols. Nichols is, as I recall, and it's been a while since I read Judge Nichols' opinion, and Judge Nichols was actually right down to, you got to shred documents. Right. That's what this statute out of Enron was meant to address, was the destruction or alteration of physical evidence. You got to do that. Judge Katsas had a little more nuanced view that it would just simply had to do with evidence without, being too definitive or limiting on what the nature of that evidence might be.
Right. I thought Katsas had it right. I mean, the statute does say, it doesn't say shredding in it, right? It's like the destruction of documents, records, blah, blah, blah. But, back to that Yates case, the fact that the Supreme Court had to tell them that fish are not records, you should have clued these judges into the fact that the Supreme Court was not going to go along with this broad interpretation that they gave. So, but credit where credit is due. Nichols has, done the right kind of analysis, and so did Judge Katsas on the circuit.
There was another Supreme Court case that's quite a bit older, but it dealt with the very issue of the word otherwise and what followed it. There's a different context. I don't remember all the context, but it was a case called United States versus Begay, Begay. And I think Begay has been isolated by the court in later cases, but there's language in Begay that basically just answered the otherwise question.
Right.
Exactly in line with what I think. And if I'm not mistaken, I think when I argued it, I kept pointing to Begay more than Yates. But
right. Well, I mean, they shouldn't have to be reminded about Yates, but apparently they did. Right. But the whole point of Yates is the holding of it is not fish aren't records. The whole point of Yates is get out of here with this argument that fish are records. Yeah. Right. Like, what are you doing? You're just bastardizing this statute because you want to pull in conduct that it doesn't apply to. And we, the Supreme Court, are here telling you don't do it that way.
Okay. Now, there's a couple other twists in the procedure of getting to the court that I think are of interest to people that don't necessarily follow this kind of stuff.
Right. Okay.
So the case is going to now go back to Judge Nichols, but the three defendants have the right to take the adverse decision out of the appellate court up to the Supreme Court.
Right. So just so people are clear, so the defendants won in front of their district judge, their trial judge, and then the government appealed that to the Court of Appeals, and the government won in the Court of Appeals. sort of, with this cobbled together horseshit opinion 2-1. And then
Eh,
because the government won in the Court of Appeals, then the defendants had a right to go and ask the Supreme Court to reinstate basically what Judge Nichols had done.
Exactly. So, but now the way this works is the three of them file separately. They're not collective. They have three separate cases rising out of their own three individual cases, and so there's three different cert petitions filed in the Supreme Court in the summer of 2023. And the Supreme Court gets 10,000 or more cert petitions a year. I don't know what the actual number is, and they deny all but 100 of them, right?
Right.
And they deny most of them without the other side of the case having to even respond. They just issue orders, denying cert, and that, the case is then back to wherever it came from, and that's where it's disposed of. So you have these three cert petitions pending in the summer of 2023. And surprising, I think, to the Justice Department, in September or October of 2023, the court, well, actually, what happened first is the Solicitor General's office filed a notice with the court that it was going to decline to respond. So it's like the Solicitor General's office can't just say, oh, yeah, we've seen this, but we think this is really a frivolous issue, so we're not going to bother either to waste our time or the court's time by creating a response. And oftentimes that's the perfectly appropriate thing to do, and the court just denies cert and moves on. But in this case, after the Solicitor General's office sent that notice to the court, a couple of weeks later, the court ordered the Solicitor General's office to respond to the cert petition. Now, this is still in the status of the court is just considering whether to hear the case. It's not really considering the merits yet, just whether or not the case should be taken up by the court for its, on its docket for the, next opening on the calendar. So the Solicitor General's office had to respond. Now, I've read that response, and it is a little bit dismissive. It sort of, it just obviously.
Nothing to see here.
Yeah, exactly. We got 16 of the judges in the district court all saw it this way. The appellate court decision, it's maybe a little bit fractured and a little bit muddled, but you know what? They will smooth out the edges of that in future decisions. Obviously there's going to be other issues that are going to come up on 1512. There'll be future appellate court decisions on 1512, and we'll make, we'll smooth or we'll clear up the muddy waters.
Right. They really, really, really did not want the Supremes to take this case.
Right. Yeah, because the stakes were so high, which is what's now happened. So they filed their response, and I think it was in late September or late October that they filed the response, and then nothing happened. And then there was, there was kind of talk in the J6 community among the lawyers that it was set for conference on a particular day, which means that the judges would discuss whether or not to take up the court. And then that day came, and it was carried over to the conference the following session, which means that the judges did not vote. They did not make a decision yet on whether to take this court. They were going to discuss it further. The next session, I think, was who died recently? Was it Justice O'Connor?
Yes.
Yeah. So the next session, I think, was the day that she passed, and they canceled the conference. So it didn't get taken up that day. Then, if I remember the timing right, they announced on the 7th. No. So help me here. The Jack Smith's the immunity opinion gets appealed to the circuit court on the 7th of December.
Right.
Jack Smith asks to bypass the circuit and go straight to the Supreme Court.
Right.
A week after that.
Right.
The Supreme Court denies that cert pending judgment, and the next day grants cert in Fisher without further conference.
Right. That's right.
It was like back-to-back days. It's like, there's a message there.
Right.
So But when the court took up the case, remember, it has 3 cert petitions pending: Garrett Miller, Jake Lang, and Joseph Fisher. It only took Fisher's case. And that was important at the time, something that I remembered from my time at Justice. You, depending on which side of the case you're on, or which side of the subject you're on, you want the court to take up the case that has the best facts for you.
Right. Right. They might all have the same issue, but the facts make a difference.
But you're right. You want the most sympathetic fact pattern from your point of view to be, undergirding the legal question that has to be addressed. Well, without question, Joseph Fisher was the best fact pattern. He'd
I
only been
thought
inside
his
the
brief
Capitol for
was, yeah.
well, that's the other thing. Well, no, that's the next thing on my show. He'd only been inside the Capitol for 7 minutes.
Right.
And I don't think, he was charged with some other offenses, but I don't think there was anything really, extreme.
No.
My whipping boy Jake Lang, on the other hand, also had a cert petition pending, which wasn't very well written. But Jake Lang is standing outside the tunnel with a mask and a shield and an aluminum baseball bat in his hand, beating on the police.
Right.
Very well documented on video. So it's
Right.
that's not the guy you want the Supreme Court to consider whether 1512 is an appropriate charge.
Right.
So they took the Fisher case, and that's in the communications among various J6 defense lawyers. We've got a listserv of several hundred people on it. That's the first thing I blasted out is they took the right case for us.
Right.
And they left
not
the
for the government
aside.
Right.
Exactly. And that was the first sign. And the other sign was, and I think I've said this before, the other thing that was significant to me was if they thought the outcome in the circuit court was correct, this is not the kind of decision where you're going to have a split in the circuits develop down the line. This is a proceeding before Congress. This is never going to be in another district. It's never going to be in another circuit. This kind of charge for interfering with a congressional proceeding is only going to happen in the District of Columbia. 16 of 17 judges had already taken a stand, and 2 out of 3 judges in the appeals court. If the court thought it was correctly decided, it would not have taken it.
Right.
The fact that they took it, to me, was a huge tell. 1, they took the right case, and 2, they took it at all. And then I started doing some research into the history of, the recent history on, interpretation of obstruction statutes, which is consistently against the government.
Right.
And from that point forward, I was confident this case is going to end up as a win.
I thought so the whole time. I thought they would take it. I thought they would reverse it. So it's just been so glaringly obvious to me since Justice came up with the idea to prosecute this statute for the J6. It's been obvious to me that that's wrong the whole time. So I wasn't surprised they took it or that they have reversed it, but thank God they did. So the other thing is we mentioned briefly, but I thought Fisher's brief was very good.
Well, so that's worth mentioning. Joseph Fisher was represented by the Federal Defender's Office of the Middle District of Pennsylvania.
Right.
And the brief was exceptionally well written, but that's to be expected. I mean, the federal defender's offices around the country and all the judicial districts generally have a fairly high caliber of defense lawyers because that's who they hire. Those are not offices where they hire people right out of law school and let them learn the ropes doing misdemeanor DUIs. Those cases don't exist. They are general, and the other thing about it being a good training ground is they're only in federal court, similar to federal prosecutors. It's the only work they do.
Right.
Now, and they also have appellate sections.
Right.
So they have groups of very good lawyers that all they do is write briefs.
Right.
And they write briefs not only for the appellate courts, but they write briefs for the Supreme Court. So I could never have produced on my own what they're able to produce as an institutional office.
Right.
Then they had the ability to attract the interest of an attorney named Jeffrey Green, who runs the Supreme Court lab practice, or I can't remember exactly what it is, at Northwestern University School of Law, or maybe University of Chicago. one of those two, Northwestern, University of Chicago, very, high quality law school, and he runs a lab for third year students on Supreme Court practice. Well, he's
Right.
also argued 20 or 30 times for the Supreme Court.
Right.
So you've got a guy that this is his professional life, and he has been before the court many times, and you've got an extraordinarily well written brief out of the Middle District of Pennsylvania Federal Defender's Office, and that's the one the court took.
And it's an interesting confluence because, a lot of defense lawyers are on the left. That's always the way it's been. There are very few of us on the right who practice defense law, but there are some. But and this, so they might politically, lefty lawyers who are defense lawyers, not be aligned with what happened on January 6th, but they do not want the government to be interpreting these
That
statutes this way.
that's really the misunderstood and funny part of this when it comes to the federal defender's office is, yeah, there's a lot of liberals that stack the federal defender's office, but they just don't like the Department of Justice, and it doesn't matter who's running it.
Right. And it doesn't matter who the defendants are. They're Republicans, defendants, Democrats, whatever, who the clients are. They hate DOJ. They don't want the government to be distorting these statutes all out of shape because it's not right, just in a general sense. So, yeah, so I thought it was a very good product, and I'm thrilled that they came out the way they did. So, should we discuss the actual opinion at this point?
Sure, I'd like to turn it over to. I mean, I can talk about it, but I want to hear
Yeah.
King talk about
Yeah.
it a little bit and
King,
your views. And is Steve around, or did you have to?
he's here, but dragging a little bit today because we've been lugging furniture and boxes.
Well, we're going to have to go to him for the Chevron, so he might need to grab
Yeah,
a bottle of wine.
yeah. He's sitting here listening with the glass in his hand, but yeah, Chevron's more his thing. So, King, what did you make of the opinion on Fisher?
Well, it confirmed everything we said.
Yeah.
We
Yep.
they bought the
Let's
arguments.
let's say it. Let's say it. We were right, you guys. You leftists. We were right. You were wrong.
Justum generis, or Justum. We've talked about this on other chats, and basically, it's a doctrine that allows the court to interpret a statute in a situation where the first part of a sentence or subpart lists some examples, and in this case, it lists some examples of things not to do under this statute: destroy documents, records, uh, things dealing with the impairment of evidence that might be used in a proceeding. And then it has a catch-all, and of anything else that would corruptly obstruct, influence, or impair the proceeding. The issue is the second part, the catch-all, is it in any way limited by what came before that? And the court held yes, it was.
Boy, and
Uh,
Roberts doubled down in the argument, as I remember, on the Latin.
he did,
Yeah.
and the theory is there's two ways you can look at it. It could be a catch-all that basically subsumes everything, including what just went before it, and makes it all surplus. Or the proper way to do it is to narrow the reading of the catch-all to only include things that are in the same category as what just went before it, the impairment of evidence.
Right. So that's what they ruled. Um,
They,
and
they, they made another point I think is equally valid. Uh, Considering the many other obstruction statutes on the books, all there in the same uh, section, with different penalties ascribed to each different actions, like things like intimidating witnesses, threatening witnesses, destroying evidence, destroying books and records, uh, et cetera, et cetera, et cetera. Each one of those separate sections carry with it a different penalty and sometimes a different mens rea, that is, the intent element, may be slightly different than some other one. This catch-all, read the way the district courts in D.C. and the D.C. Circuit had read it, basically wipes all those out and turns
All the
everything,
differences, it boils it
yeah,
all down.
and,
Yeah.
and boils them into a 20-year maximum
Right.
felony,
Right.
uh, which makes no sense.
Right. So it's not a model of draftsmanship. We can all agree on that, right? The Congress could have done a better job drafting this thing and making it more clear. But if you're applying any kind of common sense to it, you just cannot come up with the interpretation that DOJ argued.
Unless you're political.
Right. All right. Unless you have an agenda and you're just using this statute to push that agenda, which prosecutors are not supposed to do.
Well, it's I mean, it's been obvious for a long time that the Department of Justice has had only one gear in dealing with January 6th, and that is, pedal to the
Lock them
metal.
up, throw away the key.
Everything they do in every one of these cases is dialed up to the extreme. Even when they know they are likely to lose on some issues, they don't care. They would rather ask for the moon or ask for the stars if it means they might get the moon.
Okay.
They and this is most obvious in the way they handle
Sentencings.
sentencing.
Yeah.
They just ask for every possible enhancement, no matter how illogical or unsound it is based on the facts, and they just put their head down and bulldoze their way forward. And using this statute and interpreting it as just this all-purpose dragnet is perfectly consistent with that attitude. Well, if your attitude flows from a point of view that the people involved here are actually enemies of the government,
Right.
and this is what we have available to us, we are going to use the biggest caliber handgun that we can find.
Yeah. Right. Well, this is not the rule of law. When you do things that way, that is not the rule of law, which is the main problem. Now you have the Justice Department not using the rule of law. So, well, the
Now, I think we're gonna need to shift, some of these other subjects,
right,
or we're gonna be on this one topic all night. But there are a couple of, I wrote a Substack article, or actually no, I wrote an article that went out in Red State yesterday that is entitled "A Tale of Two Readings." It may not be all that it
right,
seems, and I have a point of view here on some of these issues from the standpoint of a practitioner, and you and I talked about this, and the fact that Joseph Fisher's case was in a particular procedural posture that doesn't necessarily apply to everybody else. There's 355 cases I heard today where this statute has been charged, because Fisher's case was essentially put in neutral while this issue was chased up through the appellate system. He still has an indictment pending against him. Other charges, I've never looked at it. I'm not exactly sure what they are.
I think they were all
This
misdemeanors.
will
I think this was the only felony he was facing.
Okay. So this will now wind its way back down to Judge Nichols, and Judge Nichols will. Well, actually, no, I take that back. That's not what the Supreme Court said. The last the last sentence says, remand this to the circuit court to consider the indictment in light of our interpretation herein.
Right. They basically sent it back to the circuit to tell them this is
So
the
the court
right way
didn't
to look
even
at this
reach.
statute.
Yeah, and then decide if that is properly alleged under the facts. Now, I did an analysis, I think, today, where I looked at what is the of the charge against Joseph Fisher, and it's pretty benign. It says, that he amply interfered with the official proceedings of Congress in certifying the electoral vote under the Electoral Vote Act. So the factual allegations against him have 100% to do with entering and remaining inside, and nothing to do with any evidentiary impairment.
Books or records or
So
whatever. Right.
right. So that is going to be a pretty simple determination by the appellate court. I think that on this language as charged, an offense has not been stated. Now, let's talk about Justice
Yes.
Jackson's
Right.
concurrence, where she has, I think, I mean, I can't say for sure because I'm not sure it actually works this way. If she joined the majority so that she could write a concurrence rather than a dissent, and maybe it would have more sway. But what she said is that she agrees that this has to be an evidentiary. There has to be an evidentiary aspect to this to make it consistent with C1. But oh, by the way, the electoral ballots are documents, and by interfering in the process, they in effect interfered with the electoral ballot counting, and that might be enough to keep the cases on the beam.
Right. As a documentary evidence issue. Right.
Yeah, and then I'll allow you to weigh in with the comment you
Oh,
made to me when
oh,
we talked about this, because this is yours. I haven't wanted to
yeah,
step on
I
that.
was hot about this because she says in her opinion, well, and so if that theory would be valid, then the Department of Justice can and should prosecute Fisher, nevertheless prosecute him under the statute.
Under
Under
1512. Under
1512.
1512.
And I just think that is outrageously, unacceptably inappropriate for a judge to say whether the Department of Justice should prosecute someone. A judge can say that they can under this theory, if assuming they have whatever facts, blah, blah, blah. But to give the opinion, a judge to give the opinion that the government should prosecute someone is unbelievable. Totally, totally unacceptable. It is not their job to tell the executive branch whether to prosecute or not. A judge should be totally neutral on that point. So I cannot believe she put that in writing.
Question.
All right,
I got a question.
let me step out a little bit here. Okay, let's go
Go
ahead.
ahead, King.
I read that and immediately what I thought she was doing was between the lines telling Jack Smith, go after Trump.
Yeah, I think so too. And she can opine that look, in her view, it would apply to documents, whatever, blah blah blah. But to go further and say, and they should do that, is completely unacceptable. But I pick up your point, King. I think so too. That was to try to signal to Smith that at least one justice would be open to that interpretation of the statute to be applied to that way, and that potentially could apply to the former president's case. We should touch on that a bit as to whether or not we think what effect we think it will have on Jack Smith's prosecution of Trump.
Well, Judge Chutkan in the Trump case actually wrote that she thought there was an argument that even if the Fisher case was reversed on the by limiting 1512 to impairment of evidence, that the Trump case would remain alive because of the aspect related to the quote phony
Alternate electors.
electors.
Yeah, I agree. So I'm thinking that there's going to have to be motions practice now in that case. Maybe Smith's office will have to clarify what facts are they actually relying on. What's their theory of prosecution under 1512? And that would not be uncommon if you have a statute that's been interpreted to cover some things and not others, and then your indictment isn't saying which one. There's mechanisms for both the judge and the defense to force the government to basically pick a lane, and so the judge can make evidentiary rulings about what evidence can come in, limiting the government to the theory that it has elected. Chip, did you want to weigh in on that?
Well, okay. So now I've gone outside. So if you hear ambient noises, you'll just have to understand that's where I'm at. What have you been doing today?
Me?
You have not read my Substack article that talks about how Fisher impacts the DC case?
I saw it, but you know what I've been doing today. So
No. Okay. So I wrote a long Substack article today for paid subscribers only that goes over this
yeah,
exact
in a
issue.
lot of detail. Yep.
I think Judge Chutkan and Jack Smith have been planning for this outcome for months.
It's clear Smith has, and Chutkan's open to it.
Yeah. And there are three aspects of the indictment that I sort of I carved it up today, kind of anticipating the immunity decision tomorrow and this decision today. There's a big chunk, as King points out, of the indictment that goes over the fraudulent well, even before that, there's a big chunk that just talks about everything that President Trump was saying in the aftermath of
all the stop the steal
election
stuff.
day.
Yeah.
Right. Now I think that is First Amendment political speech protected activity. In the absence of anything else, I don't think it has to do with it. He can say whatever he wants, trying to maintain the morale and support of his supporters while he goes about looking at whether or not there is any mechanism to challenge the outcome of the election. Then you have, starting on November 18th, the indictment transitions into the Eastman memo, and then the sequence of events in several states to attempt to bring the Eastman memo's idea to fruition. And that's all of the so-called fake elector scheme. And then those are actually delivered to the President of the Senate on December 14th, the same day as the Electoral College meets, and those votes are cast and sent by the governor of each state to the President of the Senate. Now, to me, okay, so and I think the Trump's lawyers even conceded in the immunity argument that that's probably going to end up not as official conduct. So if that's not covered by immunity, and it clearly looks to be some kinds of documentary fabrication of information or materials for an official proceeding, and that's a big question whether or not that's something that was not answered by the court Friday, which is this ceremonial counting of the votes an official proceeding
for
as contemplated by
purposes
the
of the
statute?
obstruction statute. Right. And I want to be quick to point out too that you're saying it clearly would be, but really it's clearly that's what the government's theory would be, right? Yeah, there are defenses to whether or not it was fraudulent or false or whatever, all of that.
But the bottom line is, who do you think wins that argument?
Well, for purposes of whether it can be tried, probably the government in front of Judge Chutkan. Exactly. But I just want people to know that doesn't mean that President Trump won't be able to defend. Right, he'll still be able to defend in trial.
Right.
Yeah.
Now I'm thinking more of in the practitioner's mind how this is likely to play out.
Before you go there, get into the weeds just a little bit more. What was presented to Congress were the, quote, official electors certified by the governors of the respective states with basically a list of electors and a certification signed by the governor and a seal attached. That was the official. The unofficial was identical, except it lacked the certification. So in what sense do the, quote, unofficial or fraudulent or whatever you want to call them, what sense does submitting those pieces of paper to Congress impair any evidence?
Well, they're evidence of the Electoral College vote.
No, they're not claiming to be certified.
Well, okay, King, I agree.
Right, and see, this is my point: is that there are factual defenses. Is what I want people to know. So even if,
all right, but before we even get there, I was going to get back to the idea of there's no way that I can
Bless you.
see to dismiss
Right,
it.
exactly. This is the point. We're making
This
the
is a
same point.
trial
Yes,
question.
it's a question to
It's a
defend.
trial question that's going to be for a
Right.
jury as to whether, the Smith calls him a fraudulent scheme, fake electors. He has all those characterizations that he's entitled to make in a charging document, which is a piece of
No,
advocacy.
but
And,
my point is he has not described any evidence that's been impaired.
well, see, but Robert's decision goes beyond that. Robert's decision talks about creating evidence. We're talking that he cites to that 11th Circuit opinion where a defendant shaped a witness's testimony.
Right.
That's manufacturing evidence. And that's really, I get into this in my article, that I think that is Roberts sort of leaving open the door to this narrow path. And back to where I think that is going to stand, I think as soon as after the immunity decision comes down and it goes back to the circuit and then back to the district court, Judge Chutkan is going to set a trial date 88 days away, which if it gets back to her on July 10th, 88 days would be August 6th. And she's going to have deadlines between now and then to deal with all these issues.
Right.
All the motions, she is not going to allow any kind of pretrial order that pushes beyond October 6th with one caveat. But back to the indictment. So if you just accept for the
Now,
moment.
wait a minute. Wait.
that-
Slow down, Ship, because you said, I thought I heard you say August, and I think you meant October.
October
Yes, October
6th.
6th. Yeah.
So now we go back to the indictment. So we've got the First Amendment protected, jawboning, so to speak, state officials trying to slow down the certification process that is going to go toward Biden. Then we've got behind the scenes the mechanics of this process of creating alternate slates of electors, which is something that has happened in the past. And then we shift to the next thing in the indictment is about 9 pages or 10 pages of his efforts to employ the Department of Justice and the Vice President to enlist them in the
effort
in the process, in the effort, right? So I think that section of the indictment probably gets carved out as official business. And I think that came up in the immunity argument.
Mm-hmm.
Some of the judges pointed that out. Like he's dealing with the Department of Justice, and then the argument became, if you remember, well, but he's got an ulterior motive, and it was no. If it's official conduct, if it's covered by immunity, we don't
look at the
behind
motive.
it at the motives.
Right.
It is or it isn't. If it is, then it's immune and it's off limits.
Right.
Motive, regardless.
So
of motive.
where this is
well,
going,
I think that whole section
comes out. I do too.
I think Jack Smith just X's it out and says we're not gonna do any of the Jeff Clark stuff. We're not gonna do any of the Barr stuff. That's all coming out.
Right. Also, they're not going to be able to put in all this shit about the riot either, I don't think. Do you?
That's the next point. The next section of the indictment talks about the events of the day and his speeches, the speeches of his supporters, all leading up to the violence, which I didn't hear. I only heard this described today for the first time, as that was supposed to be a veiled threat towards Pence, that, hey, get back on the team or these people are coming for you.
Oh, they were probably planning to use those pictures of that fake gallows. Right.
Yeah, that is actually like 3/4 size. It's not even it's not even to scale.
Right.
It's a 6-foot person stood up next to it and their head was over the top. But you wouldn't know that from the pictures they used. So that's that last section. And this is something that I've tried to make a point of. If the fraudulent elector scheme, or whatever you want to call it, in effect is over on December 14th, when those documents are sent, the violence of the day is irrelevant. Right. If that's the basis of the 1512 charge, which is this document-related evidence related, whatever you want to call it, and it involves those fraudulent elector slates, that scheme ends for purposes of prosecution on the day they're sent in, because from that point forward, they just sit in the Senate
Right.
chambers waiting for January
Right.
6th.
Right.
So the events of the
If that
day,
was obstruction, then it was completed. It's like creating a forged document. When it's done, it's done. Yeah.
right.
Now, how does the First Amendment fit?
Well, see, the problem with the First Amendment defense is you don't have just pure First Amendment activity. You have First
Right.
Amendment activity combined with actions, and therefore the First Amendment activity becomes evidence of intent. What is the intent behind those
Right. And it can
actions?
be used,
That
your things you say that are First Amendment protected can be used that way. But
I'm not talking about free speech. I'm talking about
yeah,
right to petition.
petition. Right. Exactly.
So
Right.
if I'm not aware of any case that says the right to petition is any way qualified on the truth or falsity of what you're petitioning for. You're petitioning the legislature to
Adopt your
adopt your
position.
view of things.
Hmm.
Yes,
Right. Yeah,
yeah,
exactly.
yeah.
Right. Now, I suppose you could say, yes, you can do that, but you can't do it unlawfully, right? Like you can't hold a gun to the guy's head and say,
well,
I want you
yeah,
to vote this way. But yeah,
but we're talking about a piece of paper,
right. Exactly.
a piece of
Right.
paper that on its face is not certified,
Right.
contrary
Exactly.
to an alternate set of papers that are certified,
Right.
and
Exactly.
and
It's
and
like
and
it's
the
not a fake deed if it
it's
doesn't
not
have the
fake.
seal.
And
Right.
it is what it is, and the
Right.
and the
Right.
the Congress is asked to pick one,
Right.
just
Exactly.
like they did in 1960.
Right.
So I fail to see if he carves his case up that way. I don't see how he gets around the First Amendment.
See, I don't either. And I'm with you, King, that although these are factual defenses to be raised at trial, folks, they're not a basis for throwing the charge out pre-trial, unfortunately, as far as I can tell. But it raises a point that I have raised repeatedly, which is the idea, and now I'm going to use the Latin, okay, of nunc pro tunc. Okay, lawyers do things nunc pro tunc all the time. This is the idea that a judge usually issues an order that says that the order is effective nunc pro tunc, or sometimes people agree that documents are effective nunc pro tunc, meaning basically it's like the legal version of backdating. Okay, so you agree, or the judge orders that this thing's going into effect as if it was already in effect at an earlier time. And lawyers draft documents to go into effect in this way all the time. It's a necessary legal tool. And so I have never been able to understand how they're actually going to be able to claim that this alternate slate of electors is fraudulent when they're not trying to deceive anyone. It's your point, King. They're not trying to pass that off as a certified thing from the governor. They know it's not. They're not saying it is. They're saying this is a stand in alternate that if things work out the right way legally, then these documents can be used, presumably by the Congress in this instance rather than a judge, to say, well, basically, we're just going to treat these as if they were as if they're the correct ones because we have determined that they are. Do you guys follow what I'm saying?
Yeah, it's. I think a better way to put it is it's equivalent to filing some sort of contested claim. I know it's contested. I know it's disputed, and we're asking this tribunal to rule in my favor. That's what it really is, in
Right,
essence.
right,
And 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 that worked for President Kennedy in 1960.
right.
That exact procedure worked.
But some of the leftists are saying, well, but the document says this person is a duly elected elector, and they weren't at the time. And I'm like, yeah, but we do that all the time where we say we later on issue this
Yeah.
nunc pro tunc idea and say, okay, but legally we're going to say that that was true at the time. It doesn't make the document invalid.
It's a it tees up the controversy, and
Right.
it sets your position out. My position is these people were duly and lawfully elected, and those certified folks are frauds. That's
Right.
it's a contest. It's
Right.
a
They're right
dispute.
and we're wrong. No, we're right and you're wrong. And but because you have to have legal documentation because the law requires certain things to be done by certain days and whatever, a judge can basically come along later, or the Congress can, because they have the legal authority in this instance, and say, all right, what we're going to do is we're going to pick this slate and we're going to treat this legally as if it was the one that was submitted on the date when it was supposed to have been submitted on, with the proper certifications and all of the stuff, right?
Yeah, the controlling law is a little bit ambiguous, but is
Yeah.
clear on one point. If the certification by the state wasn't based, didn't follow uh, all of the possible uh, ways to contest the vote in the state. That is, there was a drop dead date,
Right.
I think December 5th.
Right.
If you got your thing signed and certified and all appeals and contests over with by December 5, that those electors were conclusive.
Right.
Congress had to accept them. But if you went past December 5 in terms of the governor hadn't got around to certifying yet, or the court cases were still going, if you passed December 5, it was no longer conclusive. And it was up to Congress to decide whether this elector won versus some other.
Right.
And, and so what Eastman had in mind was preserving the ability as to those states that didn't meet the drop dead date, the
Right.
conclusive date uh, of December 5, to preserve the ability to contest the elections in those states and
Right.
convince Congress we got cheated. The election was stolen, and uh, he hoped if the Congress count got delayed to go back to the state legislatures and get them to say it, and hopefully that would have some meaning to Congress. But
Right.
it's
So
still up
it's
to
like,
Congress.
exactly, but it's just like placeholders. And so I'm just astonished at these prosecutors and these leftist lawyers. They act like this is just so obviously fraud on his face. And I'm like, yeah, but it so obviously isn't. What the hell are you talking about?
That the whole theory got tossed out by the court in Nevada.
Right.
There were criminal charges brought in Nevada, Arizona,
Right.
and
Right. And the
Georgia.
judge in Nevada had the same view I did. He was basically like, what? Lawyers do this all the time. What are you talking about? Right? Documents have to be signed by XYZ date, and we all miss the date. And then what happens? You get a judge later to say, well, we're going to treat this legally as if it did happen on that date, because that's the only way the thing's going to get resolved. So there you go.
So
Right?
so I'll get back to my original point.
Yeah, go ahead.
The alternate electors did not phony up and forge a fake certification signed by uh, the governor, a forgery. They didn't do that.
Right.
That
Exactly.
that might have fit what Roberts was talking about.
Right. I agree with you. Then it is like a fake document that you're trying to pass off as the original. That's not what happened. So,
But you think it has to go to the jury?
well, I think um yes, because I think that's a factual defense. Now, you could say, all right, well, that's not what's alleged in the indictment. I'd have to do a closer reading of the indictment again to see whether or not maybe what they have alleged, you could argue, as which is where you're going with this, that it just, even if you use the Supreme Court's narrowed interpretation, what's alleged still doesn't fit within what's left of 1512. It somehow is outside of it. So on its face, the indictment doesn't charge a crime under the new interpretation of the statute. But that would require close reading. So I think that's possible. I wouldn't rule that out.
But Chip, what's your view?
You gotta unmute yourself. Ship,
Man,
are you still there? I see him, but he's on mute. So maybe he's dealing with something there at the house. Um, so we'll catch up with him in a minute. So yeah, King, I'm in agreement with you. I think there are a lot of defenses there still. Oh, there he is. Hey, Ship.
Yeah, I'm back. I'd take a quick break. Um, let me mention one last thing that I had in mind on the Smith decision, and then I'll probably step out for most of the rest of what we're going to do, other than to pop back in and out. Just it's dinner time here.
Yeah.
Um, uh, I think in an odd way, not necessarily surprisingly, the Fisher decision, which might force Smith to trim back dramatically the factual allegations
Yeah.
and the likely outcome of the immunity decision, I think within 7 days of that case being back in the DC circuit, we're going to have a 15 to 20 page superseding indictment, much shorter, much simpler, much more direct, and right on the path to a trial. I
Well,
think
they would be smart to do that, but do you think they've done it?
I think that right now, after the debate performance last week, I think right now they're kind of looking at this as maybe the last hurrah.
So they've
And this
got to get
case,
the case to trial.
this case has got to get tried. If nothing else, no matter how ridiculous it might be, it will pin Donald Trump in a courtroom from the first week of October through Election Day.
So
5 days a week.
right. So what you're saying is, based on what's going to come out tomorrow with the immunity, if they try to go forward, the government, on anything that might even arguably be immune, then the former president will have the right to appeal that again.
Yep.
If they instead trim their case down to stuff that just where there's just no argument that it's immune, they might be able to, with Judge Chutkan helping them, force the case to trial before the election.
Now, yes, but they can't stop them from filing an appeal.
Right. They cannot.
The appeal may be improper. It might not be meritorious. It might not be subject to interlocutory, intervention, but they can still send it up there. And then an odd question develops, which is, are there 4 justices on the Supreme Court willing to, behind closed doors, say, this election is not going to turn on what 12 Biden voters in the District of Columbia say? There's another way for a verdict to be rendered, and that's by 175 million voters to say.
So if the case moves from the district court, so people understand, if the case moves by virtue of notice of appeal from the district court to the Court of Appeals, then the Court of Appeals can put it on a fast track. The Third Circuit did this recently for Hunter Biden. But even that will take a few weeks to brief and argue, and that would put it past the date of the election.
I
If
don't think they'll
we're,
take a few weeks. I think they might
yeah,
just dismiss it sua sponte as not
well,
subject to interlocutory appeal.
but if it's based on an allegation of the immunity, they won't be able to do that, right?
I agree with that.
Yeah. And if they did, then the former president can ask for help from the Supreme Court.
That's right.
If there's any genuine view that he's being tried for conduct that's immune, then that's not going to go forward. But if, as you say, if Smith can get his act together and narrow the case down to conduct that is clearly not immune, they might be able to force it to trial before the election.
with one big if, Judge Cannon. She
Okay, so let's
she
throw her in here. Yeah, go ahead.
yeah she has a couple of things pending that could upset that timeline in DC. One is the motion to disqualify and dismiss the case because Smith is
Not
n-
properly appointed.
not properly appointed and is being paid uh, illegally without a proper appropriation from Congress. Those kind of go hand in hand. She has not ruled on that. Uh, she could really throw a monkey wrench in the Smith operation if she rules against it. That's one. Second,
Well, that won't. Let's stop with that one, King. So that would not be binding on Judge Shutkin up here in the D.C. Circuit. But what effect do you think it would have?
would it not? Why not? It has to do with his status. He's bound by it. D.C. courts might not be, but he is.
Right.
He would have to take that up on appeal.
Right. Then he'd be looking for emergency relief from the 11th Circuit, right? Is it the 11th?
Correct.
Yeah, it's the
Yes,
11th.
11th Circuit.
Yeah.
Now
I'm just thinking this through because normally one district judge court's opinion doesn't bind any of the other district court judges, right?
well, you've got
It
that.
does bind the party. You're right about
It
that.
binds the party.
Right. So she could certainly issue an order that says he cannot appear on behalf of the United States, in any federal court, and that would make it clean. We should look at this interesting point. We should look at what the proposed order is that the defense gave her for that, because they have to have thought this through, and if not, they should have.
Yeah, I'm sure they have. It has to be as broad as possible.
Yeah. So it'll be interesting to see what she actually issues in the language of her order.
Yeah.
And then it'll be, well, I don't think that the special counsel's office will try to flout that in DC if the order is what it is. They'll try to get an emergency appeal in front of the 11th Circuit.
Now, and I don't know what the odds are whether she'll of granting that or not. She has it under advisement, and will.
Did you listen to that argument or any of the reporting on it? Because I did not have time.
I've read the reporting. Yes.
Yeah. And did it seem like she was interested in ruling?
She was interested in it. She had tough questions for both sides, so I can't say if she's leaning one way or the other.
I noticed that she let the parties submit supplemental briefing, but she would not let the amici submit any supplemental briefing.
Right.
But I think the deadline for that has passed, so presumably they filed, and now we're just waiting for her to rule, right?
Correct. Now, and there's another proceeding that she has. She's delayed it, but she's going to have it, and that is on Trump's motion, his discovery motion, to define
Ship, put yourself on mute. Ship, yeah, there.
to define the prosecution team to include related agencies, like
Right, for discovery purposes, yeah.
for discovery purposes, and she wants to hear evidence on that.
Right. Go ahead, Chip.
Let me go to something that got lost in the attention of the. And sorry, I'm over a barbecue, so that's the noise in the background. That got lost in the attention of the debate, and then Friday. She should order on Tuesday or Wednesday, denying a Franks hearing on the motion to suppress, but granting an evidentiary hearing on the particularity issue, over breadth, and Leon.
Okay, so the audience is not going to know what any of that is. So you're going to tell us what a Franks hearing is.
Okay, a Franks hearing is essentially an allegation by a defense that the agent who drafted the affidavit in support of the search warrant knowingly included false information or intentionally omitted material and relevant information for the purpose of influencing the decision of the judge to issue the warrant, and the allegation must be stated with substantial whatever. It can't just be like toss off allegations. You got to have substantial evidence of such. She denied that. She did not find that the suggestions or the allegations in the motion regarding either willfully false information or knowingly omitted information met the standard to warrant a Franks hearing where the agent would be called to testify and answer questions on those issues. But she granted an evidentiary hearing.
Wait, stop there so people understand. So basically, the defense was arguing that the to get the warrant, the FBI agents put shit in the warrant they shouldn't have, or left shit out that they should have put in order to persuade a judge to issue the warrant when it shouldn't have been issued. And in order to even get that kind of a hearing, where an evidentiary hearing on that, you have to make enough of a showing for a judge to say, yeah, this is something we need to look into. And she ruled you didn't make enough of a showing, so we're not having a hearing on that. That's the end of that issue. So,
Correct.
but
Now, but
she went further. So go ahead with the next thing.
so now this was all part of the same series of 2 or 3 days of hearings that started with the validity of Smith's appointment, and also argued in those series of issues was just the legalities of the motion to suppress. Just based on the allegations in the motion and the response of the government, but without any sort of further evidentiary showing. She issued an order several days later that said that there's an insufficient evidentiary record for her to resolve that issue, and basically the defense will be allowed to call government witnesses on the issues raised regarding the lack of particularity in the warrant, which I don't know that that's really subject to, but you could go into how the agents executed the warrant to explore the question of whether or not it was sufficiently particular for an agent of ordinary experience, whatever that standard is.
Right.
You look at their experience, their training, their knowledge, and what they did, and then the question becomes, okay, did their search comport with the Fourth Amendment in all respects?
All right, so
Then, if
stop
it
there. Stop there. Stop there. So folks understand this particularity is an idea under the Fourth Amendment. So in the bad old days, pre the Revolution, there were what were called general warrants. Basically, this was a warrant that said this guy did bad stuff. Go search his house and bring back any evidence that proves he did the bad stuff. Okay, and that came to be known as a general warrant. So basically, in general, go get the shit that we'll use to make a case against the person. And the founders didn't like that, unshockingly. And so there is a requirement in American law that a warrant particularly describe the things to be searched and seized. So now warrants have to say what it is that the cops are looking for and where it's likely to be found. And there's a gloss overwritten that of kind of a reasonableness standard, right? But the warrant itself has to particularly describe this. So this is an issue that defense lawyers will sometimes raise on a motion to suppress, because if evidence is seized pursuant to a general warrant instead of a particular warrant, then that evidence cannot be used as evidence in the case. So this is what the former president's lawyers are trying to do here, which is say this was a general warrant, and therefore evidence seized pursuant to it can't be used at trial. And so what the judge is doing here is saying we're going to have a hearing because she wants to hear from the agents, because there's rules about what the warrant says on its face, and then there's rules about the way that it was actually executed and carried out by the officers. And that's what Chip's talking about. The experience of the officers matters not for what the warrant says on its face, but for the way that the officers applied it when they showed up at the house. So it's no good if you have a warrant that particularly describes the stuff to be seized and where it's at, and then the cops just run around doing whatever anyway and exceed that. So this is what this hearing is about. So she said that yes, they're going to have a hearing, an evidentiary hearing, calling witnesses on that question.
Correct. And also on the issue of good faith, which is the Leon standard, that even when there is a lack of particularity or overbreadth, or the agents exceed the scope of the warrant in their search, were they nevertheless acting in good faith reliance on the validity of the warrant in the sense that it had been signed by a judge. So she's going to allow an evidentiary hearing, testimony from the agents on that subject as well. Now, let me say this. Prosecutors, federal prosecutors, I know it's different in state court, federal prosecutors never want their agents being examined under oath in a pre-trial matter.
Right.
It does two things. It creates testimony under oath for your agents that they're now locked into. You can't get away from a trial if they say something they shouldn't say. And it gives the defense an opportunity to learn more than they know. federal system for historically, going back decades and centuries is not quite trial by ambush, but it's not far from it.
It might as
A-
well be.
yeah,
Right.
a lot of times, you show up in court, you start calling the witnesses. Now, there's discovery rules that give the defense access to information about what the witnesses are expected to say and what the evidence is that's been found and the nature of the allegations, but you don't get to take depositions and find out what the witness is going to say on the stand when the time comes. That happens in the trial. So when the defense has an opportunity to start calling FBI agents, or more importantly here, maybe calling Department of Justice lawyers and having them explain themselves, it's a potential gold mine. The reason that possibility exists here is, remember, the search warrant was executed before Jack Smith was appointed. You may very well have a completely different set, or at least to some degree, a different set of lawyers involved in that search warrant than are currently prosecuting the case. The government keeps out the witness stand, even if they're fact witnesses, the lawyers prosecuting the case, but it's not a given that they can keep lawyers off the stand who are no longer involved in the case if they're fact witnesses.
Right. Right. Okay. And so you were telling us about that this is what Judge Cannon has done for a
Was
larger purpose. King, go
but
ahead.
yeah, but what you have there is a tension between Judge Cannon's case, which is percolating along with upcoming evidentiary hearings that Ship just described and the one I described about defining the prosecution team, which that sounds, reading Trump's motion on that and the evidence he attached, that sounds like it's going to be a big deal. It could go on for days. And when are those hearings, those evidentiary hearings to take place? And is Judge Cannon going to set a trial date that could upset the one in D.C.?
I don't think she has any. I don't think she's in a position to set a trial date that is going to interfere with the trial date that Judge Chutkan is likely to actually set. She might have some hearings that take place in the 88 days leading up to October 8th. And when Trump's lawyers say, Your Honor, this is impossible. We can't be in two places at one time. Judge Hutchin's going to say, well, there are a lot of you. I don't see why not.
Right.
What if one of Judge Cannon's hearings is in October?
Chutkan's going to say trial trumps a hearing.
Yeah. That's what the inner district rules are going to say too. So
Even if the hearing is set first.
Well, but my point is, I think the trial date's going to be set before Cannon gets to the point of setting a trial date. The trial date. I think we're going to see a trial date in the D.C. case in the next 15 days.
not that the trial will be set in 15 days, but that we'll know what the date is.
Exactly.
Yeah.
Exactly. And then that will
Right.
be a marker. That'll be a line in the sand that says, don't set anything in Florida after October, whatever.
Right. I agree that that's the way that will go. So, okay. And then the really the $64 million question, as people used to say, is going to be whether there's any argument that Trump could take back to the Court of Appeals, probably only on the immunity issue, right?
Yeah,
In order
that's
to defeat that trial date.
correct.
Yeah. Well, I mean, I suppose his lawyers could try, and I mean, in the normal world, there's nothing you can do about the trial date that the judge sets. Right? You can't go to the Court of Appeals and say, we don't like this trial date that this judge set. Do something for us. They're going to say, what are you talking about? You can't even ask us that. But this is not a normal case. You know, the election is when it is. He's going to have been nominated in the Republican convention. I forget what the date of that is. It's next month, I think. Or is the Republican one in August? And, maybe if you were his lawyers, you might take a shot at trying to say you cannot be serious that you're going to put him on trial the month before the election.
Particularly, the trial will not end
Yeah, no
by the
kidding.
time of the election.
Right.
Yeah,
Based,
I think there's probably it would have to be on a writ,
Yes.
and it would have to. I think in some way, I think the writ would have to say there's no possibility of getting a fair trial in the District of Columbia the month before the election.
Right.
You cannot expect to find 12 jurors. I don't care how dismissive you are, or how accepting you are of a statement that I can put everything I know aside and judge this case totally on what the evidence presented to me is and the testimony of the witnesses. That magic language ain't going to cut it.
The only case I know of that comes close was Senator Stevens' case.
Well, but he wanted a
He,
trial within
yeah,
70 days of his indictment in August
yes, he
because
did.
he wanted to be acquitted before election day.
Right, I know, but I'm thinking that's the only case I know of where there might even be some language you could look at about the problem of having a trial so close to the date of an election. So I'll see if I can dig that up this week because, as you say, we're probably going to find out the trial date in the next 2 weeks. They made arguments. I know his lawyers were very good lawyers, and I know they made good arguments about, the effect on the electoral process. I'll see if I can find those materials. Well, that'll be very interesting. We will keep a close eye on that, and we can talk about it again. So, King, you're right that Judge Cannon may indirectly have a lot to say about whatever this new date's going to be, and Trump's ability to move the case away from Judge Chutkan again to the Court of Appeals obviously will play a significant factor too. And he's going to have both the 1512 argument and the immunity arguments to use. And then this third option we've just raised about, he can't possibly get a fair trial when he's, standing for election for the highest office in the nation. And,
I don't
within a
think
month.
I don't think he get a fair trial anywhere that close to the election.
Right, I agree. And that would be a persuasive point to be like, even in a district that was favorable to him, right? How could you possibly expect jurors who are voters, to render a objective verdict?
Yeah, imagine this fact scenario. Imagine this fact scenario. This may be what you put forward. This trial will go beyond election day. These jurors
Right.
will
Yeah.
go into a voting booth to decide who they want to be the next president.
Right,
At the
exactly.
same time, they're going to be voting whether to send one of those two candidates to jail or not.
Right. Right. No, it's just completely impossible. So it'll be fascinating to see, well, what does Jack Smith try to do? Do they try to force the pace and get the trial in before the election, right? Or will they just be like, that can't be done and let it ride, and we'll see what happens. But given his track record, he'll try to force the pace. So we'll see about that. All right. Well, we've done nothing but talk about Fisher so far. Let's turn to some of the others briefly. So, two that I wanted to point out quickly before we then talk about Chevron. The first one is about the Securities and Exchange Commission. So the name of this case is Jarchese, I think is how it's pronounced. And in this case, the Supreme Court decided that if the Securities and Exchange Commission is going to impose what are called civil money penalties, so this is a non-criminal civil monetary sanction that the SEC and a bunch of other agencies impose on people for allegedly engaging in fraud or in other ways violating regulatory rules and requirements. HUD does this a lot, several other agencies. Lots of them have the authority and power to do it, supposedly. And I have as long as I've been practicing law, thought that this was totally unconstitutional, that the government could come along in this guise and take your money away from you to punish you for bad conduct, but no jury. Um, and not only no jury, but no federal judge either, because the judges that hear those cases are administrative judges. Most of the schemes, also, the administrative judge is not a neutral judge that's set up like in an independent body of administrative judges that hear these kinds of cases, but instead the judge is actually an employee of the agency that is trying to take your money away from you in the first place. So the SEC has a bunch of these administrative judges that have been carrying out this civil fraud scheme. And, unsurprisingly, people who try to defend themselves in these proceedings invariably lose. Now, the statute gives the agency, in this case, the Securities and Exchange Commission, the option to bring those cases in federal court or to bring them on the administrative side. And there's various rules about that, but they do both. And, unsurprising to anyone, I would think, they do a lot better in front of their own administrative judges. They have an overwhelming success rate there, 90, high 90s. Whereas when they bring the cases in federal district court, in front of the more neutral, anyway, federal district judges, they only have about a 60% success rate. And this was completely consistent with my limited but still firsthand experience with SEC cases where when you would try to defend them, the SEC lawyers were completely insane about their view of the facts, their view of the law. It was extreme, just extreme in the sense of what they thought they could get away with. And they coerced pleas, effectively, agreements, settlement agreements, out of people because there was no way they were going to lose in front of their administrative judges, and they knew it. And most people don't have the stomach or the wallet to fight that. And so people would agree to settlements for things that if they had had the right to have a judge and a jury hear them in federal court, they would have had, some of them anyway, would have had a shot at being found effectively not guilty on the civil side. So this week, the Supreme Court finally has said that no, that is not the way it is, that you have got a right to a jury for those cases. So thank God, it's only been, decades that we've been using this scheme, which is unlawful. But this is one of a series of a series of cases where the Supremes are cutting back on, Fisher's another example, the Supremes are cutting back on the power of these government agencies and the power of prosecutors to distort and extend the law past where it really is. And as a libertarian, I am thrilled by this. Now, this will require the Congress to do its job, which it hasn't been doing for a long time, in terms of writing the laws and saying what the law is. But it's a huge step in the right direction. And the other case in this same vein, it was a case called Erlinger. And in that case, same kind of thing. It's a jury type question case. Let me pull it up here, what I had to say about it the other day.
I could do Erlinger.
Okay, go ahead.
Erlinger is a long simmering issue involving the Armed Career Criminal Act.
Right.
A defendant who's convicted of a violent offense and who has 3 or more prior violent offenses is subject to a mandatory minimum 15-year sentence under the Armed Career Criminal Act. Those 3 priors can be state or federal offenses. And so the issue comes down to, after the defendant is convicted, and Erlinger was convicted of simple gun crime, being a felon in possession of a firearm. But then in a post-verdict decision by the judge, which was the process that has been established for a long time, the issue came down to, did he have 3 prior convictions that made him an armed career criminal subject to a 15-year mandatory sentence, rather than the felon in possession conviction subjected him to a potential maximum sentence of 10 years. So the judge's determination at sentencing was the difference between a maximum of 10 or a minimum of 15. So that's a factual well, let's say it's a determination that changes the defendant's potential exposure to prison time. In 2000, the Supreme Court decided a case called Apprendi versus New Jersey, and announced a watershed rule of criminal procedure that said any fact that increases a defendant's potential maximum sentence must be tried to a jury and found by the jury unanimously by proof beyond a reasonable doubt.
Because you have a right under the Sixth Amendment to be tried by a jury, not a judge.
Right. So Apprendi, the issue was, and this was very in vogue at the time in the Clinton administration and the aftermath of the Clinton administration, Apprendi was a violent offense, firearm offense of some type. And then the kicker was a separate New Jersey state statute that said if the judge decides that this is a hate crime, if you were, motivated by bias against your victim because of race, ethnicity, religion, whatever, then your sentence went from a maximum of 10 to a maximum of 20. And that was a decision made by the judge. And in that case, the judge actually gave the defendant 12. So the judge went beyond what the maximum would have been on the underlying hate crime alone that the jury returned a verdict on. So the judge's decision that the crime itself was motivated by a racial animus increased his maximum, and the judge added 2 years to his sentence. So that was the fact pattern that led to the Apprendi rule, which was any factual determination that increases the defendant's potential maximum sentence has to be made by the jury at trial by a standard of proof beyond a reasonable doubt, unanimously. So now back to the Armed Career Criminal Act. So Apprendi has been good law, obviously, for 24 years. Been many decisions in the aftermath of Apprendi, dealing with different kinds of questions, but with the same kind of central premise. The issue that came up in Erlinger was the question of the number of prior convictions, and a decision that I can't remember which case it came out of, but there was an issue that 3 convictions for purposes of the Armed Career Criminal Act had to be 3 separate occasions. In other words, it couldn't be 3 different felonies for one criminal event. You had to have been convicted 3 different times for 3 separate criminal occasions in order to satisfy the 3 prior felony condition that elevated you to a 15-year mandatory minimum. Well, the accepted practice until Erlinger was that the judge would make the decision. But in Erlinger, the Supreme Court said the question of how many occasions there are is fact-bound. It has to look at the facts of the 3 prior events to decide if they're one crime composing 3 felonies or 3 different crimes, each composing 1 or more felonies. That's a fact-bound determination, and under Apprendi, those facts must be determined by a jury beyond a reasonable doubt. Now, this actually begins to impact Trump's New York case, because this is the most recent pronouncement by the Supreme Court that any fact that increases a potential maximum sentence must be submitted to the jury and found unanimously. In Trump's New York case, the fact that he was trying to cover up another offense is what made his paperwork crime other than a misdemeanor and into a felony. So that fact had to be established by the jury beyond a reasonable doubt. But the kicker there is the jury did not decide unanimously which of several potential crimes he was trying to cover up. And the judge told the jury they didn't have to decide unanimously. Well, Erlinger seems to be going down the path that no, that decision is bound up in the question of whether it's a felony and not a misdemeanor, thereby increasing the potential maximum sentence from 1 year to 4 years. And that fact, what crime he was covering up specifically, has to be decided by the jury unanimously by proof beyond a reasonable doubt.
Right. And we've been discussing this on Twitter ever since Trump's case, verdict came through, that the way that that judge gave the jury instructions was kind of technically correct under the law that existed at the time, but that law might be subject to change because the law is trending more and more, and Erlinger is a good example of this, of requiring the jury to be unanimous on more and more, and requiring more and more things to be decided by the jury, not a judge. So this is a good trend for the law. And I know, oftentimes folks, those of us who are right of center, are law and order people, right? And obviously we want people who've done bad things and who are armed career criminals, right, to serve sentences and be removed from society because they're a danger to other people. But at the same time, we have to be doing that according to a rule of law that comports with our constitutional values. And, juries should be deciding whether people are guilty of crimes and whether and how bad that crime is according to the strictures that we've imposed on felonies versus misdemeanors and so on and so forth. And if the Congress is going to write statutes that say your sentence is longer because you've committed uh, a bunch of crimes, you're somebody who commits crime over and over again, that is also something that juries should be deciding. That you would think that would be simple. Well, did he commit 3 prior felonies or didn't he? But the way people are charged with crimes can be complicated. So a person could have been involved in a single course of events and potentially have been prosecuted by, let's say, 2 different states for what effectively amounts to the same conduct that occurred over, let's say, a 1-day period or over a weekend or
Let me
whatever.
jump in here with a collateral point on the very point you're making, a much more cynical one. In Hawaii, I regularly see rap sheets that show somebody has 34 convictions, but they were
Right,
arrested 3 times.
right,
Okay, this whole thing of the number of convictions is a
right,
stat chase. This is how
right,
law
exactly.
enforcement
It's
agencies
stats.
demonstrate to their funding sources how hard and effective they are.
They're racking up
Exactly.
numbers. Okay, now they've racked up numbers on your rap sheet, and now you were really only involved in 1 event, but the judge has decided you were involved in 3, and now you're going away for 15 years mandatory. That is wrong. So I have no problem, even as a defense lawyer, with sending people to jail for the nonsense that they've done, but we cannot be just doing that without carefully evaluating whether it applies correctly in each individual case. And so I think Erlinger is a great move in that direction. So, having discussed those 2 brief ones, we want to do the Chevron issue now. King, do you want to weigh in on either of those, on Jerkesi or
I
Erlinger?
had a old story, but it's getting late. I guess I'll save it. I'll say this:
Okay.
the SEC case, uh, the jury trial case, relied on an old 1980 something case, Grand Financiera, which came out of a bankruptcy case, and that case sort of turned the bankruptcy world upside down because it held that actions brought in bankruptcy court before a bankruptcy judge, who's not an Article 3 judge, he's appointed by the chief judge in the district, serves 8 years or so. And there were certain actions considered core bankruptcy cases to which were always tried to a judge since bankruptcy started,
Since
since
forever.
forever.
Right. Yeah.
But some bright lawyer said that, I'm not sure that's right. And they got into the law books, the ancient law books, and it turns out to determine whether you have a right to a jury under the Seventh Amendment. You have to go back and look this is in civil cases. You have to look under English law from the 16 and 1700s and determine was there an equivalent English law type case that had to be brought in the courts of law as opposed to courts of equity. If it was equity, it could be tried to a judge. You're not entitled to a jury. But if it was a case, you're entitled to a jury. And they applied that analysis in Grand Financiera. I had a case in bankruptcy court, one of few. Judge didn't know me, and I argued. This was before Grand Financiera came out was decided by the Supreme Court, but it was percolating up, and I knew about it, and I made the argument that the case I had was my client was entitled to a jury under the Seventh Amendment, and the answer I got from the judge was, "Mr. King, look over to my right." I did. "You see any chairs?" "No, sir." "Look over to my left. You see any chairs over there?" I said, "No, sir. We don't have even
We
chairs
don't
for a
do
jury."
juries.
The other side's motion to strike your jury demand is granted.
Well, because the courtroom wasn't set
That's
up
it.
for it, you're out of luck. It's hilarious.
But
Yeah, and sometimes that's the answer you get, and even though you know you're right, and the judge is gonna rule the other
well,
way
I went
anyway.
back to the office pissed off
I
and whipped
bet.
off
Yeah, because like the law was supposed to matter,
and
not his
whipped up
courtroom.
a motion for reconsideration, and I
Uh-huh.
sent a paralegal down to the district court down the street from the bankruptcy court. They went in. I had him go in and take a photograph of the courtroom, and my argument, I said, I have an exhibit for illustrated purposes. This here's a courtroom down the street that has chairs for the jury, and the judge who sits in that chair and up on above wears a robe and is an Article 3 judge, and that's where I should be.
That's hilarious. Okay. Did that work?
That didn't work, the case
Of
piddled
course not.
around for a while until the Supreme Court bailed me out, and I got my jury.
Right. That's funny. Okay, so let's talk Chevron for a few minutes and then we'll try and wind this up. King, you want to take the lead on this one?
Sure. The facts of the case are fascinating. They involve small business fishing boats or family-owned fishing boats uh, on the East Coast uh, who 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 are subject to regulation as to how many fish they can catch and so on. Uh,
I mean, how is it that there could be all these fish cases in the Supreme Court?
yeah, exactly. Uh, they, but they the I forget the name of the regulator even. The federal regulator not only
National Marine Fishery. It's NMF, National Marine Fisheries Administration, I think.
that sounds right. Uh, but the regulator doesn't stop at determining how many fish you can catch and how much they have to weigh and what you have to do to them, et cetera. They go beyond that. They to monitor. They think all fishing boats need to be monitored. So they want a federal monitor to go out every time a boat goes out fishing, and just to make sure they're complying with the law. Uh, the question is, who pays for the monitor? And
Let me
the,
guess. Not them.
not the
You get
not the
to.
federal government,
Well,
but
let me introduce a fact here. I believe there's 13 federally regulated fisheries in various parts of the seacoast of the United States. And the statute specifically provides in the Pacific Northwest fishery, which has huge fishing companies, multinational billion-dollar corporations, that those companies do have to pay for the monitors. That is in the statute. But those are multi-billion-dollar operations.
And foreign fishing boats who come all the way across the ocean and fish in our waters also have to pay for the monitors. Uh, but there it stopped. The statute stopped, and the regulators said, "Well,
Okay.
that
And so this is the Congress
yeah,
saying you guys get to
yeah."
pay.
Well, the
Okay.
Congress says these big dudes out in the Northwest and the
Right.
foreigners have to pay.
Right.
But
Right.
and
That's what I'm saying. That's at least that's our elected representatives saying
right,
that, right?
but didn't
Okay.
say about anything about a mom and pop owned fishing boat
Right.
on the East
Right.
Coast going out of Maine or Rhode Island or somewhere.
Norfolk
Yeah,
or wherever.
uh,
Right.
it's silent. So the regulator said, "Aha, that's an ambiguity. So we will fill that in." Every
And see, that's not an ambiguity. That's one's in, one's out. What is unclear
well,
about that?
the regulator decides that's ambiguous. We get to regulate. They mandated that the fishermen have to pay for the monitor, which costs about $700 a day. And the two different cases, and in both cases, the cost of that monitor was eating up in one case 20% of the revenue, and in the other case, the other plaintiff was going out for 8 to 12 days. Uh, they had a quick freeze operation on the boat, and they could stay out much longer. And so they had to carry that monitor out there for almost 2 weeks, and it was driving both of them into bankruptcy. So
And is the monitor an actual
the
person?
actual person. So
Oh my God. Can you imagine? Now you got to house this guy on your
yeah,
boat for.
and feed him and then pay his
Yeah,
salary. Yeah.
right. Right.
So
Right. And probably do his ISP and all the shit,
yeah.
right?
So
Jeez Louise.
they filed suit saying the regulation was illegal, and it got to the Supreme Court under the Chevron doctrine that the Supreme Court wanted to hear those fishing boat cases because this is our avenue to have another look at Chevron. The Chevron doctrine says this: where the statute is in any way ambiguous or silent on a particular point, the regulator can step in and interpret the law. And where that happens, the courts, will give deference to the, and basically be pretty much bound by what the regulator says the law means,
Their
their
interpretation of the
interpretation.
statute.
And
Right.
the federal regulators are nothing if not aggressive in expanding their
Right.
powers. They took that and ran with it. Uh,
Yeah, they
they
did. Now, what I want people to know is because the right of center thinks, of course, Chevron is bad. And it is. I'm not saying it's not. But what I want people to know is what was the situation before that that caused the court to adopt Chevron? And because, it's always a reaction against what's happening at the time, right? So pre Chevron, what would happen is the agency, whatever agency, would have a regulation that interpreted the statute in the following way, blah, 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 right? Let's just take the EPA, and they would be trying to impose those regulations. And somebody would sue, and you get in front of a district judge. Okay, and you would expect that a district judge would just apply the law and say the regulation either complies with the statute or it does not comply with the statute, right? Because statutes trump regulations. If a regulation does not conform to the statute or isn't authorized by the statute, then it's illegal and a judge can strike it down. Okay, and that sounds like great. It's a straightforward application of law. But in practical reality, because judges are human beings and regulators are human beings, what was happening too many times was, especially when the administrations changed and they wanted to change their policy approach to things, the new administration or the next administration, whichever one coming in or the one just going out, would have had one kind of policy approach to something. And if the district judge that they got in front of ideologically disagreed with that approach, then they would just say that the regulation was outside the scope of the statute and they would strike it down. In a situation where the regulation probably was not actually outside the scope of the statute, it was just a policy way of approaching the statute different from the policy way that this particular judge approved of. And that happened left and right, right? And so the Chevron doctrine was supposed to be a way to try to keep the judges from imposing their own ideological views, especially in a situation where, for lots and lots of these statutory authorizations from the Congress to specific agencies to do things, it's a specialized area. And the district judges are not specialists in almost any of these areas. So they are tasked with knowing what the law is and applying the law. And in a difficult way, they are often tasked with applying the law in a situation where they are not familiar with the underlying subject matter. But nevertheless, as judges, their obligation is to apply the law to the best of their ability. So they are forced often into making rulings on things that, left to their own devices, they don't not even interested in, much less understand. But so this was the background, that Chevron was supposed to be trying to fix this problem of an agency that had a reasonable interpretation under the statute, but one which a judge didn't agree with, would then overrule it, saying that it was unlawful under the statute. And King, you mentioned that Chevron, basically, the doctrine required the judges to accept the agency interpretation. I always thought that was a misreading of Chevron, right? Chevron really says that the judges were supposed to defer to the agency's interpretation, and especially more so in situations where the agency has a lot of industry competence or knowledge in areas where a district judge might not have. Um, and that didn't necessarily mean that they had to slavishly adopt whatever the agency's regulation was, especially if it did violate the statute. But a lot of judges used the Chevron doctrine to basically get out of having to make difficult decisions in areas where I think they felt like they didn't have a lot of competence. And it sort of took on a life of its own and got to the point that you were saying, King, where it was almost like binding, right? Binding on the judge. And I don't think that was really the intent of
It
Chevron,
wasn't
actually.
the Supreme Court in Chevron, which came out in 1984. Uh,
Yeah,
it it articulated a two-step analysis that I'm not going to get into, but it required the courts to go through a two-step process to determine whether the regulation uh, was lawful. The As I said, the regulators took advantage
yeah,
of
they
what
did.
they were given in Chevron and just went way overboard in their interpretation of what the law was, and then fitting more and more broader and broader regulations under their uh, new interpretation, and then they change it. They would, like, you get a new administration
Yeah.
in, and they change, they throw out the old and redo it all.
Right. And the theory of Chevron was that, okay, there can be more than one reasonable way to apply a statute. Well, that's true, right? So, that part is not wrong conceptually, but as a working system, it just took more and more power away from the judges and gave it to these, executive agencies, administrators, people who are elected by nobody, um, and there's no way to form a check on them if you basically tie the hands of the judges. Although, as I say, I think often the judges were happy to have their hands tied because they didn't want to get into all of this policy stuff. They didn't want to get into understanding the complexities of areas that lie far outside of their competence sometimes. But I always thought, okay, but this does still not relieve you as a judge of the obligation to say that this statute has a meaning and the regulation has to fall within that meaning.
The
So, all right, so tell us what
well,
happened then.
over the years, the Supreme Court had to deal with this variation of Chevron and that trying to articulate a unifying principle, and they failed. They
Right. Yeah.
could not get their arms around a clear Chevron principle that worked in every case. Uh,
Right. Because there isn't one. They haven't been able to
they have
figure that
they,
out yet. There isn't one.
so the issue is, are we going to overrule the Chevron case? That's the only
Right.
thing they wanted to hear in these fishermen's cases. And they held, yes, it's time to do away with Chevron. And Justice Roberts wrote the opinion, and he pulled a rabbit out the hat. He did something that no opinion had done up to now. Why, I don't know. But he went back to the old 1946 Administrative Procedure Act and found a section that basically said, if there's an issue about what the law means, that's for the courts to decide, not the regulator.
And it always has been. And the judges basically just didn't want to do that hard work. So they didn't.
And so Justice Roberts said, well, whether you like it or not, we have to follow the law. And the law says
Right.
this is for the courts to decide. The regulators cannot control on what ambiguous statutes mean. That's solely that's a judicial function, and judges, you've got to do it. We'll allow the regulators to inform us as to what they think that may help us make our decision, but at the end of the day, it's a court decision. Chevron is hereby overruled.
Right. Because it's really two different things. Whether the statute is ambiguous is one thing. Whether an unambiguous statute can nevertheless be applied in different ways is a policy choice. Right. That's not ambiguity. That's left and right. When the left wins elections and is in the White House, they see things one way. And when the right is in the White House, they see things a different way. That's has nothing to do with whether the statute is ambiguous or not. Right. And I just want people to understand that just because Chevron was overruled does not mean that the district judges are not going to weigh seriously whatever the current administration is, weigh seriously, give serious weight to, I should say, the agency's interpretation of the statute. They still are going to, especially in statutes that are technical in application and outside the scope of what judges, are used to ruling on. They're just not going to sort of slavishly bow down to that anymore, which is effectively what they've been doing for the last, good grief, 40 years now,
Yeah.
right?
Well,
So this is a good
but
decision, but
even better for fish lovers, you'll be happy to know that the bankrupt
right,
fish, the potentially bankrupt fishermen, do not have to pay for the monitors because,
right,
at least not right now, they sent it back to the lower
Yeah,
courts to decide the ambiguity,
yeah.
whether monitors are covered.
Let me jump in. I want to make that point. I was struck by the fact that right at the top of the opinion, Robert's opinion says, we took this case to determine the Chevron doctrine. Basically, not stated but implied is, we're not here to determine whether the fishermen have to pay the fee or not.
right. Yeah, good grief. But that should fall out under the heading of it's not ambiguous. If some things are in and some things are out, that's not ambiguous.
Let me make another comment. Something that I was struck by when I went back and looked at these today, and And to me, there's something to it, and I'm not exactly sure what it is. Roberts wrote Chevron. Roberts wrote Fisher.
Yeah,
Roberts wrote the SEC case.
right.
Uh, I looked at that and I thought, was he, were these opinions assigned? Because I thought for sure Gorsuch would get Chevron because it's just been his, like, and he writes a concurrence.
Yeah,
Um, and it maybe was that what they produced wasn't going to get 5 votes after they produced it.
right,
And so
right.
he stepped in, took maybe what they started, wrote a different version of that could get 5 or 6 votes. I don't know,
Votes,
but it's
right.
odd to me that he, if you look at the spread of the opinions, the majority opinions in this last month, he's got a significantly higher number than any of the others.
Right. Well, I found reading his prose, he writes in a very clear, clean, right? It's not as erudite as what Gorsuch is writing, right? It's not as flavorful as what Kagan writes, but it's, I think, a more clear distillation of principles. And when you write that way, it's easier for people to agree with you. So I think you're right, Chip, that he's kind of boiling it down to its essence and then writing it in a way that more people can get on board with amongst the 9 of them.
His clerk probably found the Administrative Procedure Act. So that's how it happened.
Probably. Oh, that may very well be. I don't know what was in the briefing there. I meant to pull those and read them, but I haven't had time. So, but yeah, I did also notice that, Ship. I'm like, another Roberts opinion. That's interesting. So, well, I think it's a good development, but I just, kind of want to say, all right, we're sort of back to where we were before Chevron, though, right? Are the judges going to be able to resist ruling unlawful stuff that probably is not outside the scope of the statute, but is just things that they don't agree with? And, on the other hand, when I step back bigger picture and look at it, I like that better than having unelected bureaucrats be given so much power, which is basically what Chevron ultimately did. Because if an individual district judge is just, let's say, hostile to environmental regulation or, whatever, and is going to consistently rule against the agencies can always appeal that to the Court of Appeals, right?
Yeah, I think maybe an overlooked or something that we just haven't mentioned yet is I think in some very significant ways, the Chevron doctrine has led to the expansion of the administrative
Yes,
state because now
absolutely.
so many regulatory decisions rest finally in effect with them and
Right. And the Congress, I think, once they realized that, is when they really went crazy with delegating all of this stuff to the
yeah, we don't have to make
agencies.
why should we have to make votes on things that might cost us at the next election? We'll just let the EPA decide.
Right. We'll just give them oh, here's the general guardrails. Now you guys go actually do the legislating. Right. That's not what the court intended with Chevron, right? They were trying to get away from judges being too activist. And instead, they just overly empowered the administrative state, and that caused the Congress to stop doing its job. It was a interrelated series of problems that only, I think, resulted in a overall bad outcome. The 3 branches stopped functioning and delegated too much of their power to these administrative agencies. So hopefully this is a great course correction. There will still be the old problems that they were trying to fix in the first place, but I like those problems better than this excessive administrative state. Ship, one thing people have been asking we should touch on before we go is what effect Fisher's going to have on the J6 defendants. How can they take advantage of it? So you want to give a quick rundown about this?
Well, I mean, it's so this goes back to, in some ways, sort of the uncertainty that remains because Fisher's case is in the procedural posture it is. So,
Right. His case is going to be
yeah.
tried because
So,
he didn't plead and it didn't go to
yeah.
trial
So
yet.
now his case goes back, and even let's assume that
Yeah.
the circuit court upholds the dismissal and sends it back to Nichols. It's almost certain that Nichols is going to allow the government to go back to the grand jury and see if they can come up with a factual formulation of something that Fisher did that fits within the narrower definitions or interpretation of the statute given by the Supreme Court.
And and maybe they can't do that given that guy's
Right,
actions.
but that
And
becomes fact bound.
they yeah,
And
right.
so that's kind of the situation that every defendant whose case is still pending is in if they're charged with 1512. Is the charge I mean, I put this on X a couple of days ago. I had a defendant, a new case indicted on Wednesday, 2 days before Fisher, charged with 1512C2 with the same operative language. So,
Right.
the government didn't shy away right up to the 11th hour, continuing to charge people in this fashion. So that particular case, I think I might even try the old move to dismiss an arraignment and see what happens.
Yeah. Okay.
Just for giggles. But you know what? It's Judge Nichols.
Go for it.
so
Go
so
for it.
um
Totally.
so defendants that have not been to trial yet and have the charge pending likely will succeed in having a motion to dismiss granted, but the government will have the opportunity to go back to the grand jury, seek a superseding indictment with a different formulation of the charge if they have facts that they think they can establish beyond a reasonable doubt that will prove that. Then you have defendants who are already convicted in one fashion or another and have their cases on appeal. Uh, Again, this kind of turns a little bit on what the circuit court does based on the remand, which says consider the charging language in light of our narrower definition. So defendants that are on appeal, let's assume that the circuit court says, okay, this charging language in Mr. Fisher's indictment is insufficient. Therefore, we are going to uphold Judge Nichols' dismissal and send it back. Well, now everybody that has the same charging language in their indictment who's been convicted and has an appeal pending, they're winners. All those cases are going to get, they're going to, when their appeal is final, won't happen right away because they might have several convictions or several issues on appeal. But at least they got the bullet in the round for that one. They're going to win that one. And it's going to go back to the district court, at least for resentencing, if nothing else.
Right. So basically, what he's saying is that if people are on appeal, they're going to get the benefit of the Supreme Court's decision in Fisher, straight out.
Right. So at a minimum, they're going to get resentencing with that charge dismissed. Now, if they went to trial and got convicted and then they get reversed, that I am highly confident is going to be double jeopardy. The government is not going to have an opportunity to go back to the grand jury and cure its own error. The government went to the
Right.
grand jury, got a charge, had a trial, got a conviction, and then was told, oh, by the way, your charge was insufficient and it's reversed. They don't get a second bite at the apple. Double jeopardy does not allow them to go back to the grand jury and change the 1512 charging language to something that might pass Supreme Court muster. So those people are going to get resentenced, without 1512 in the calculation. So there are a handful, I think, that maybe only had there are a handful of early cases where the government was only charging a 1512 with misdemeanors. The 1512 goes away. Now that defendant is only going to have misdemeanors and he's no longer to be a convicted felon. Probably a lot of those cases, the defendant's probably already served the sentence, like my client, Jake Chansley. He's already served his sentence. His only conviction was 1512. Can't get the time back. So we have to look at, are there other reasons he might want to try to address it? Now, and this is an issue that you and I have discussed that I don't want to get too far into on a spaces. There is an open issue about whether or not somebody who pleads guilty to the 1512 and then is in a position to benefit from Fisher, whether that is double jeopardy. That is a question that doesn't seem to yet have a clear answer. And there are a lot of defendants in that position. Because what the government did as a general practice between early 2022, so roughly a year after the event when the cases started to be disposed of because the discovery was finally complete, it took the government 11 months to get the discovery out. So you couldn't have any trials or guilty pleas before the government could complete the discovery. You could, but there were very you could count on one hand. But starting in early 2022 and going all the way through, the middle of 2023, it was a very typical disposition, maybe the most common in with felonies charged, for the government to offer a single count plea to 1512 and a stipulation to 2 specific guideline enhancements, the combination of which produced a sentencing range of 41 to 51 months.
These are the sentencing enhancements we talked about a few weeks ago, you
Right,
guys,
and we'll come
where
back to that in a
the
minute.
circuit ultimately decided that those weren't
Right.
legal.
So I saw that plea offer for clients of mine 6, 10 times. I didn't have a lot of clients in that position, surprisingly, but I saw that plea offer 6 or 10 times, and I saw it in other cases where I had a reason to go want to look at somebody's plea paperwork.
Right, or other lawyers that we know that we
I
talked to.
probably got 400 or 500 sets of plea documents in a particular computer file because from time to time I want to go look at a particular person's case that as it arises, as it occurs to me. That disposition where the government said plead guilty to the 1512, stipulate to the 2 sentencing enhancements, and we'll dismiss everything else. That happened dozens of times. So that particular defendant is in an interesting position because if they move to reopen or to vacate their conviction and sentence, that's the only count they were convicted of. And there's an argument to be made that the government doesn't get to fix their problem.
Right. But even if they do get to fix it and try to recharge that person with something else, it won't be a 20-year felony with the enhancements like that 1512 was.
Correct.
So they could potentially renegotiate a better plea, basically.
Correct. The government would say, well, we want to charge you with a 231 now. Okay, well, that's a 5-year statute and it's a 6 to 12 month guideline. But then you walk into the ability of the judges to actually sentence higher than that if they want to, and that's what the government is going to ask for. So that's the second set of defendants, the ones that pled guilty or went to trial. I'm not sure there is another set of defendants. I think that basically covers all of them. So
well, you got people on appeal now. You got people who've already finished serving one way or another on pleas. You've got people who went to trial and are finished serving or are still on appeal or whatever. So pretty much everyone that had 1512 in their case is potentially going to be able to benefit one way or another.
But probably the least benefit that something can accomplish, and I have a couple of clients in this situation, and we're going to decide this week what we want to do, is get the felony set aside and get off of supervised release.
Right.
And there's a benefit to that.
Because there are lots of people that this was the only felony in their case.
Right. And while they might have served their term already, they're still on supervised release. And if you don't understand what supervised release means, it means you're essentially still serving your sentence. You're just not having to serve it in a Bureau of Prisons facility. And
it's like being on probation, but with teeth.
And by the way, if you violate the terms and conditions of supervised release, the marshals will escort you back to the prison.
Send you to jail.
So it's not like come in, slap you on the wrist, and say, don't do that again. It's come in, you have 23 more months of supervised release to serve, but your violation leads me to believe that you can't be trusted. So I'm just going to send you back to the Bureau of Prisons for 23 more months. And so getting off of supervised release is a meaningful benefit.
And also in some states, you lose your right to vote or carry a gun or other
Well, that,
things
yeah,
with a
that's just
felony
setting
on your
aside the
record.
felony, correct.
Yep.
So I have picked
Right.
up 8 clients in a little more than 2 weeks, 3 since Friday, to address their options under 1512.
Right. And so folks know there are other kinds of cases where the Supreme Court rules and then you have to have a second ruling from them saying whether or not the new ruling can be made retroactive to other people's cases. But this case is not going to fall into that category because it's because of the kind of legal question that it is. So these folks are going to be able to get automatic application of Fisher, but it's going to depend on how their case got resolved or whether it's still ongoing as to how much help it's going to give them.
Yeah,
So,
we'll leave
all right.
aside for now the question of forfeited error. That's probably a bridge too far tonight.
Right, yeah, it is for tonight, for sure. So, all right, King, have you got anything you want to chime in on that or anything else? Because I think we're to the point where we should probably wrap up because we're going to be probably talking again tomorrow night if you guys are all available. Because we do expect the Supremes to issue their final, is it 4 or 5 cases left? I think they're going to issue them all
Yeah.
tomorrow.
I'm ready to wrap it up.
Okay. All right. So join us tomorrow, you guys, because we'll almost certainly be talking about the immunity case for former President Trump and several other cases of interest. Ship, you got anything else you want to say before we all say goodnight?
Nope. Good night to everybody, and hopefully we'll see the
All right.
same faces tomorrow.
Okay. Good
Good
night,
night.
all. There, I had no intention of listening to that and didn't. So we can get started here in a second. I see people waving. Thanks, Aaron. Um, so yeah, it sounds like everything's working well. So while we're waiting for Ship King, let me ask you, how are you doing?
I'm doing fine. I listened to President Biden. Also, he's finished. He was like
Ah,
all of 4 minutes, 5 minutes.
Rosie, really? Okay,
Yeah,
maybe there's a
and
delay where Ship is. He said he needed 2 more minutes to join
yeah,
us.
he the president's message was basically the court uh, determined that the president was a king.
Did he then thereupon ask everyone to bow down?
Uh, he refused to take questions, so so we don't know
Oh my,
if he thought that as he said it.
right. As he shuffled off. Well, literally, he spoke for 4 minutes.
5 minutes at most. Yeah.
Wow. So what was the point? Like, what was the point of him doing that?
Point was that he quoted the end of Justice Sotomayor's
Mm-hmm.
dissent
Dissent. Okay.
and said this is uh, it is highly unlikely that Trump will be brought to justice before the election. So it's basically up to the people because the Supreme Court has gone off the rails, so to speak, uh, and held that the president is basically a king, although our founding principles says he's not. That's kind of what he said.
My goodness. All right. Well, I mean, just further proof they're just prepared to just burn everything down. All right. Ship has joined. Let me send him the co-host invite, and then he'll be able to talk too. Well, it's making him a listener, not a co-host. That's not good. Ship, I'm going to send that to you again. Oh, it won't let me yet. It says I can only cancel it. I'm going to invite you to speak, Ship, and then it's not letting me do any of that. Oh, here we go. All right, so Ship, now you're a speaker, and
Okay.
I'm going to cancel the co-host invite and resend it to you because it seems like it stabilizes the platform a little more when we're all co-hosts. So look for that. It should pop up. So you were listening to President Biden also. Ship, what'd you think of what he had to say?
Yeah, I missed it the first time around, so I was just watching a
Oh,
tape.
I see.
Just watching a tape of it. It's 4 minutes and 45 seconds, and every word of it was scripted. So he was just reading somebody else's words.
Right.
One of his little, speechwriters banged out, 325 words for him real quick.
Okay.
Basically meaningless for the most part.
Okay. All right. Okay. Well, so we're going to talk about this case that came down today, an historic case, you guys.
Yeah, let me characterize it in light of what President Biden just said. The court determined that President Biden is immune for prosecution for keeping the borders open.
and a host of other things too. Okay, but before we discuss the case, we're gonna do, you guys, and I've got Steve here with me tonight too, you guys. What we're gonna do, the four of us, are you ready? We're gonna laugh because I'm just thinking it's so funny. These leftist lawyers have said for months and months and months and months that this was a ridiculous argument, right? That it was an illegitimate argument. That to me, it was perfectly clear that this was the obvious answer based on the law. So I think we should laugh at them. Are you guys ready? I'm going to count it down. 3, 2, 1. Come on, you guys. You don't want to laugh at
the
Norm
the
Eisen and Andrew Weissman and all these dickheads?
I mean, as a practical matter, that is almost the most comedic thing about this. Is
Yeah,
from the start, everybody on the other side of the political divide said this is nonsense. There's
yeah,
no basis for it. It's just a waste of time. Why doesn't the Supreme Court just slap it away?
yeah.
This, Judge
Neil
Chutkan
Neil
said
was like,
there's
"Oh, it should be days. They should,
yeah
get rid of this."
there's
What?
yeah Judge Chutkan, there's no immunity. The a three-judge appellate panel unanimously in a terrible opinion. There's no immunity. It's like I think maybe the failure and the refusal to ever really take it seriously until they got Dreeben involved at the end,
Yeah,
in some ways contributed to not making a record. Maybe they want to rewind the tape and think if we'd handled this differently, might we have gotten a little different outcome with not quite as long a road ahead of us? I mean, there are parts of that opinion that, in ways, if you think back to the oral argument, I mean, remember, it was very shortly into it once Dreeben began speaking for the special counsel. The
yeah.
Roberts really went at the opinion, talking about, isn't that sort
Yes.
of a tautology? It's like, it was almost like reading between the lines. You could see Roberts, who's a very serious guy and was a long time, highly thought of Supreme Court practitioner himself, saying, this has gotten to us as a pile of shit.
Right, exactly. This is complete garbage from the circuit. Because it was. Yeah, the tautology, Steve says. Yeah, no, you're right. So I know. And he was obviously offended by that. And I think it shows in this. He's like, all right, knuckleheads, here's the analysis.
Yeah, yeah. You guys decided to file this first of its kind ever indictment 15 months ahead of a presidential election,
Right.
and then insisted that the entire process run on your schedule and cut corners and take shortcuts where necessary to accomplish that. And this is what is at the end of that path.
Right.
Well, the path, Ship, I disagree. The path began with the appointment of Jack Smith. And that dude, let me tell you, he crafted an indictment that really sounded great to all the liberal pundits. But from a lawyer's standpoint,
Right.
it created a morass
Right.
that he was caught up in. And there was no way out from that day forward.
It
And this
reminds me.
and
Wait. It reminds
good.
me in a way of what the Mueller people did when they indicted those Russian companies
Yes.
because they never expected them to defend, and then they showed up in court with lawyers demanding discovery. It's like,
Well,
oh, we
not
have to
just that.
actually litigate this case.
Not just that. The funniest thing about the entire Mueller having to defend that one case against the Russians was a prominent U.S. law firm basically came in and between the lines said, you know what? We got an unlimited budget and we can put more lawyers on this than you can.
Right, which doesn't usually happen to them. Yeah.
Right, right. Because they had the Russian government paying the bills.
Right. It's the
Um,
same kind of feel to it, doesn't it? It's like
but,
I agree with you, King. It's like he
well,
drafted this indictment, but faced with the realities of getting it through the court system, he didn't plan on.
it's the same thing that I mentioned before. They get so focused on the indictment being a press release. They
Yeah.
get so focused on the indictment telling the story into the press that they want to be able to talk about instead of, you know, oftentimes the less said the better in an
Yeah.
indictment.
Yeah.
Save it for the trial.
Right. Right. Since we still do trial by ambush in this country on the criminal side of the
Yeah,
courthouse.
yeah, but in fairness, not that I'm a fan of Jack Smith because I'm not, but in fairness about why he put stuff in the indictment, this was the first federal criminal indictment of after the Mar-a-Lago thing, but of a former president, and he needed to lay out enough of his case in the indictment to be defensible. So if he'd gone with a lean indictment like prosecutors often do, it would have been politically untenable. That's my view.
Now, I don't disagree, but I think, but they're opposite sides of the same coin.
Right.
The more he piled into the indictment and made it even a more transparent press release, he drew the same reaction.
Right. Exactly.
Steve, I agree with a big but. He drew it so broadly without concern at all for the constitutional issues
Well, and questions of
embedded.
proof issues too.
Yeah, forget that. I mean, I'm just basic separation of powers,
Yeah.
constitutional issues.
Yeah.
He ran through all that as
Right.
if they didn't exist.
Well,
He
but
did
that's
not try to at all to plead around the
The
pitfalls,
problems.
the
Yeah.
problems.
Yeah.
Yeah, but I think I agree with you completely on that, King. But I think that his whole career
Mm-hmm.
is his track record is that he's a very aggressive prosecutor, and he just charges ahead like a
Steamrolling everything.
tank commander, and the stuff you're talking about are judgment calls. Judgment
He
calls.
doesn't have any of that.
Judgment
So
calls are when a prosecutor says, "Well, I could do this, but is that really wise? Is that what I want to do?" Blah blah blah. His is, here's what the crime consists of. Here are the elements. Here's how I think I can make them. Ergo, I'm going to go for it. That's his view of being a prosecutor, as close as I can tell. That it's not a view I agree with, having been a prosecutor for 10 years, but that's his view. And it's a miserable view for somebody who's going after a former president of the United States because, well, for obvious reasons, I don't need to elaborate.
Yeah, I think a lot of that, Steve, and I think you'll agree with me, a lot of that is his background.
yeah.
When you come out of basically spending the time that he spent in justice in public corruption, when that is what you typically deal with, you're oftentimes dealing with naked graft.
Right.
And
Exactly.
there is no problem with being a tank commander in a target-rich environment with naked ground.
True.
I mean,
You don't have to
there's
have a lot of skill or judgment.
yeah, there's just, it's like a demolition derby. It's like you bounce off one and you bounce into another. But I think the point King made is a very good one. This was a minefield for him that he didn't appreciate.
Right.
Where there were going to be countervailing constitutional and policy issues, and I think it is. This is the same guy that prosecuted the Virginia governor on the gift claim in the face of a 270-year history in the state of Virginia of people coming to the newly elected governor with small tokens of
Right.
Okay, I can't think of what I mean.
We're like respect gifts,
Yeah,
honoraria almost.
Yeah.
Yeah.
honoraria, yeah, and they've been
But
doing it for centuries.
well,
And
if you
and,
want to
and
get
it
into the
was
McDonald case, which I should disclaim that I had a role in the appeal to the Supreme Court, uh, a small role, but I was involved. But it's interesting because there's a parallel because McDonald's conviction was unanimously upheld by the Fourth Circuit, and it was only when it got to the Supreme Court that the justices said, "No, we don't think so." So that's somewhat similar to Trump's case here, because I agree with everything you guys have said about Jack Smith not appreciating the minefields, but frankly, things were going entirely his way until he got to the Supreme Court. Tanya Chutkan said, "Right on. There's no immunity. No, no man's above the law." And the circuit, much to my amazement, unanimously agreed with her on that. And only by the time you get to the Supreme Court do you get people saying, "Wait a minute, we think there's another side to this issue."
The problem is the one we started out with, which is we all saw the problem. We all thought this is not correct, right? We're not crazy. We were right that all of these judges who this is their job decided to go along with this continues to amaze me. So,
and I want to. I'm going to jump ahead just for a moment,
okay,
and we'll
go
come,
ahead.
and I'm sure we'll come back to it. But I'm going to do this because I just read it like a half hour ago. I had to, after I read the opinion this morning, I read Justice Thomas's concurrence, but I didn't read either dissents. I just had to get back to doing what I was doing.
Yeah.
And then so I just went to the dissents earlier. I could not get through the first two paragraphs of Justice Sotomayor's dissent without becoming visibly angry, because her dissent begins or has two basic premises to everything in the first two paragraphs. She ignores the concept of presumption of innocence.
Right.
And she accepts as true every allegation in the complaint or the indictment for the purposes of criticizing the majority.
Right. Well, I mean, as we've discussed before, Sonia's not the sharpest knife in the drawer. Right?
We'll come back to it, I'm sure, but that was an idiotic dissent. I mean, it was idiotic. She cited. I bet she doesn't cite. Was it 35 pages? I bet she doesn't cite 20 cases, and she cited Nixon more than 20 times.
Right. No, it's like a rant. It's like an emotional rant. It's actually a bit of an embarrassment for a Supreme Court justice to be doing that. But this just shows you really that how divorced from reality and the law these people are looking at this. And, we've all been practicing law a long time. Me, the shortest amount of time, and I've been doing it 25 years. And it just is mind-boggling how lawyers and judges who otherwise I would have said were, perfectly capable legal thinkers cannot think straight when it comes to this guy.
Yeah, it is completely tedious. It's completely tedious. You can only, it's just myopic tunnel vision that this guy's the worst threat to the country since Benedict Arnold.
Right. Well, okay. So let's talk about the actual decision. Steve had made an observation earlier tonight to me about really, in some ways, how much like Nixon v. Fitzgerald this case is, really. So I want to play with that idea as we go along. But do one of you want to actually sort of lay out, okay, well, who's on what side and what did they actually do?
I can get,
I'll leave it to either King or you because, like I said, I had a chance really to kind of run through it one time, and
Yeah.
then I have a lot of pressing matters I had to start
Yeah. King,
dealing
why
with.
don't you tell us
yeah,
really how does
yeah,
the opinion lay on the page?
without getting into the details, the in-depth
Yeah. Right.
analysis, from a high level, Justice Roberts' opinion says this: we have a constitution that creates three independent, separate branches of government. The executive branch is the president, and the Constitution vests that branch, the president, with certain duties and functions that are beyond, nobody can touch them. The Constitution says the president and only the president, not the Congress, not the courts, have the authority over certain issues. Those include things like pardons, things like treaties, things like negotiating treaties, things, etc. Uh, and it's set up that way on purpose by the founders. And the issue as to immunity, first issue, is whether anything that he's charged with violating involve duties that are his alone.
What they're calling the core.
The core,
Right.
yes, the core functions of the president. And the answer was yes, there are. Among, and this is an example of the idiocy of Jack Smith. He put in there that part of the scheme involved discussions inside the Oval Office with his acting attorney general and other high ranking officials of the Justice Department as to whether they should investigate things, as to whether if and when they pushed back, he threatened to fire them and hire another high-ranking executive of the Justice Department to take their place, who would go investigate allegations of fraud. And that's the appointment clause. That the only the president can appoint federal officers, including the attorney general and the highest ranking officials in the DOJ. And Smith is alleging that activity by Trump was part of a fraudulent scheme.
Right. And
And
unlawful conduct. We talked
yeah,
about this when we talked about the oral argument. Didn't it seem like that the person who argued on behalf of special counsel, whose name is escaping me, that he conceded
Michael Dreeben.
Drebin. Yeah.
yeah,
He conceded points that were not in their favor that Smith himself maybe wouldn't have. And you can see it in the point you're making. Like they had to concede things to the Supreme Court that are inconsistent with the way they indicted the case.
yes, he had to,
Yeah, he
because I
had
mean,
to. Right.
any constitutional lawyer, any academic who understands the Constitution understands that.
Right. And
And
it's your point that he sort of blew by all of those obvious guardrails when they did the indictment.
Well, it reinforces King's point. If I can interject for just a minute here, Dreeben, who the special counsel brought on to argue the case in the Supreme Court, was for more than 20 years in the Solicitor General's office until really quite recently, a couple of years ago. and he specialized in criminal cases, and he argued over 100 cases before the Supreme Court, which is, puts him in a very small group of the most experienced Supreme Court advocates that have ever existed. So he's a smart guy, and he's hugely experienced before the Supreme Court. And so when he's arguing there, the concessions he's making are concessions he knew he had to make in order to retain any credibility. And then this reinforces your point that you made before, King, which is, Smith didn't think about that up front, because he put his appellate counsel, his top flight appellate counsel, in the position of having to concede things that undercut his indictment. And that's my only point.
Okay, so Roberts, since they conceded that point, Roberts put that in his opinion, right, King? That there's some core stuff that the president can do, and he can't be prosecuted for that. Duh.
And that's the core part.
Let me add one comment to what Steve said before we move on, and it builds on. It doesn't just frankly repeat what I said a minute ago. It is Smith's blind spot that if it's corrupt, it's illegal.
Right.
If he thinks it's corrupt,
if he doesn't like it,
exactly.
which means he thinks it's corrupt. Right.
So if he's corruptly manipulating the Department of Justice, doesn't matter. His authority over the executive branch doesn't matter. His conduct is corrupt. If it's a subject matter that is, and see, this is something that Dreeben knew. If it's a subject matter that, based on long-standing Supreme Court decisions, is exclusively committed to the executive branch, like charging decisions or who to investigate and who not, if it's corrupt, Smith didn't care. He was gonna include it in his indictment,
which is another parallel to McDonald. They had the same exact theory.
Good, King.
Yep, and somewhere I can go on about that. I've got a lot to say about that issue, but in short, we have a constitution with 3 separate branches of government, and the executive branch, the president, is one of those separate branches, and the Constitution says you, the executive, have these powers, and there's nothing the Congress can do, and there's nothing the courts can do to take them away or modify them or infringe on your absolute authority in these issues, on these, like Harden.
Right. Now, so to be clear, King, you're not saying that that's every single one of the president's duties. You're saying there's a subset that are the core that basically nobody can touch. Pardons, vetoes, appointments.
And among those are the things that we all learned in the first year of law school. Youngstown Steel says that they're committed exclusively to the executive branch, and therefore, under separation of powers, cannot be interfered in or by the other 2 branches. And I just make this point that I like to make whenever somebody doesn't seem to understand it. The court, the reason that there's an executive, or the reason there's a separation of powers issue, the judiciary is a branch. It hosts, for lack of a better word, it hosts the prosecution. Well, if the prosecution violates the separation of powers, then the judiciary would be violating separation of powers by hosting the prosecution. So
they'd be complicit, as the left likes to say.
Participating in the violation.
It's the same with Congress. Congress passes the criminal law that defines what it is, what constitutes a crime. But the Congress has no authority as to make any part of the president's core functions a crime. And when Smith charged President Trump with committing a crime by threatening or considering whether to replace his acting attorney general with somebody who he
liked better or whatever.
He liked better or somebody you thought would go after more crimes than the first guy, for whatever reason, Congress can't make that a crime. And Smith basically was charging that what he did was part of a crime. And why anybody thinks the court went off the deep end.
By pointing out that you can't do that?
Yes. I don't understand.
I don't either.
Nobody today apparently understands the way our government is structured under the Constitution.
Right. All right. So that was the first thing that Robert said. There's these core concepts, and those can't be charged. So keep going, King. What was the next part?
The next part is there's I think Roberts used the phrase the twilight zone of functions, which are not per se core, but they're part of his duties, and the duties include uh, carrying out the duties in the Constitution, combined with carrying out the duties that Congress says he has to, the laws Congress says he has to make sure are enforced. And there you have it's a gray area, but it's still within his official duties, but it's not core. Uh, Let me think of an example. One example would be enforcing a criminal law, a law passed by Congress.
So, like immigration law or bankruptcy.
Correct. And it's not a core constitutional function, except that he's supposed to carry out the laws. But how he does it, who he does it with, what judgments he makes, kind of is a concurrent uh, action of what Congress wants and what the president wants. So the Congress has a role to play in it. Therefore, it's kind of in the middle. Therefore, it's not core. It's not exclusively left to the president, something the Congress can't touch. Since Congress has authorized him and directed him to do X, Congress has some say in how doing X takes place. Did I say that right?
Yeah, I got it.
Okay. As to those, Justice Roberts developed a kind of a quasi immunity. He said since it's within the functions of the president, uh, his duties, his basically job description to carry out those duties. We're going to give him immunity, but it's presumptive immunity, which means we're going to presume on first level everything he does is immune. But that presumption can be rebutted by the prosecutor. And how do you rebut it? I'll read you the language.
So, rebutting it, when lawyers say that, they basically mean overcome. So, one side has a presumption, the other side can overcome that presumption, but usually by the production of certain kind of evidence. So, what did
And,
he
and
say the test was?
the test is this: to overcome that presumption, the prosecution, the government must show the prosecution would impose no danger of intrusion on the authority and functions of the executive branch. I'll read that again. The government must show that prosecution, in this case, would impose no danger of intrusion on the authority and functions of the executive branch. Now, your guess is as good as mine as to what
What does that mean?
what that means in practice, because I can think of 1,000 different hypotheticals, and I could come out one either way
Right. I
depending on the
took that to
particular fact.
mean the outer perimeter concept in Nixon v. Fitzgerald.
Well, no, they say that applies to the outer
Yeah.
perimeter, but
Right.
this tells the prosecutor what you have to do to get around immunity, and
You have to be going after something that doesn't really infringe on
to
his.
infringe on the authority and function of executive branch. Let me give you an example. Nobody
Okay.
has said this today, as far as
It's
I
not the SEAL Team 6 example, is it?
no, no. I'm going to get into uh, 371,
Okay.
which is fraud against the United States.
Right.
You go to the DOJ manual as to what the government must prove to, and this is, by the way, the main criminal law that that Trump is charged with violating.
Beyond 1512, which got thrown out on
I
Friday.
don't know, but this is the first. This is number one,
Uh-huh. Yeah.
even above 1512. According to the DOJ manual, the statute is broad enough by its terms to include any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function. Defeating the lawful function. You just heard me use that word, function, on the immunity issue. Defeating the lawful function of any department of government, which would include the executive branch. So he's charged with committing a crime for defeating the lawful function of his own executive branch. And then Roberts just told us that he gets immunity for that unless the prosecution can show there's no danger of intrusion on the authority and functions of the executive branch. How do you square that?
Right. I know. It's crazy. Well, I mean, it looked to me like their opinion in this regard doesn't actually they didn't actually pull out their copy of the indictment and say, well, we better look at what he got charged with, look at the elements of it. It doesn't look like they did that.
It you end up in an endless circles, which you
Right.
end
I
up.
agree. I agree. On that, on 371, you do. Because basically, so people understand, Roberts is saying the prosecutors cannot go after things that would infringe on the duties of the president. Okay. But 371 is a crime that says the whole point of it is it's a conspiracy to impede the duties of the executive branch. And that's what the crime is. So it does seem to be a bit of a rub up against one another type problem.
And
So,
and I've been thinking about that for 3 hours, and I have not cracked that code.
right. Right. It would be easier with a different statute, right? So, like, if, let's say, he charged him with bribery, then the analysis would be, well, does the bribery charge interfere with any of the functions of a government, the any of the carrying out of a government function? And that's easier to see that it doesn't, right? Because the whole idea of bribery is that it's putting private money in your pocket to carry out an official function. But you're not really being charged for the function, you're being charged for taking money for the function. So prosecuting you for the taking of the money then doesn't seem to me that it is then impeding the official function. That official function is going forward regardless of whether you're taking the money or not, and regardless of whether they're prosecuting you for it or not. So that might be the easiest one. But everything else I think is going to be very difficult.
Yeah,
Um,
I think you end up with uh, this presumed immunity is pretty close to absolute.
right. We talked about this when we talked about this in our last spaces after the argument, which was what in the world are they going to come up with that's better or different or something from what the Nixon v. Fitzgerald court came up with? which is, I think, cleaner and simpler. If it falls within, if what you've charged the president with falls within the outer perimeter of the scope of his official functions, then he's immune. And if it's outside of the scope of the outer perimeter of his functions, then it's not. That just seems so much easier to me.
So we can come back to all this, but let me go on to
Yeah, keep going. What did
what the
Roberts do?
opinion said. Yeah, he went on to do something. I was surprised he went into the depth that he did, but he took the indictment and basically kind of gave some preliminary non-binding thoughts on
I love
how.
this part. I love this part. Go ahead, Kate.
Yeah, he said we're gonna, since the idiots in the courts below us never looked at this issue,
Right.
which
We
is
talked about that too, right? And he seemed
Mhm.
frustrated by that in the argument. They didn't actually do the analysis of what was charged.
Yeah,
Was it official or wasn't it? How in the
yeah,
hell was this court supposed to make determinations?
yeah. So we've got the issue. Uh, how much of the conduct that allegedly constitutes the crime, uh, how much of that involves official duties of the president, and does any of it involve core constitutional duties of the president, which is absolutely immune, and how much of it would involve the gray area, the twilight zone, where he's only presumptively immune? And are there any parts of what he did that are non-official at all with no immunity? So you got the three categories, and
And
basically,
Roberts is like, oh, none of y'all did the analysis, so I'm going to help you out.
I'm
I'm
gonna,
going to,
yeah, I'm not gonna decide it. I'm gonna
right,
send it back to the district court. They're gonna have to, Judge Chupkin's gonna have to decide it
right. But
with
I have
based
some
on evidence.
thoughts, me, John
But I have some
Roberts.
thoughts. I have some, and uh, and this none of this is binding on Judge Chutkin, but just so you know, here's what I'm thinking. And he then walked through some of the allegations in the indictment and kind of put them into different buckets. And most of them were in the middle bucket, which is uh, presumptively immune, but we need to look further to see whether the special counsel can get over that hurdle uh, to to destroy immunity. The one aspect of the indictment, Roberts was clear. Everything that uh, Smith alleged in the involving meetings with his attorney general and the attorney general and the DOJ officials about, do we prosecute? Is there a crime here? Do I need to fire your ass because you don't see it, and I'm going to hire somebody who does? All of those were core, absolutely immune. Beyond
So,
that, practically everything, there's an argument that can be made that it is all within the outer parameters of the president's duties.
right. And Dreeben, opposed that, right? He rebuffed that whole argument. He said these things were clearly not. And so I love it. Here, John Roberts is like, well, here's an argument that it is. Oh, and here's another argument. And here's the third thing that, you could say this is the other way. I was not expecting that from him.
Well, remember Dreeben, how did he? They had a different characterization, an as applied
Yes. Yes.
not a pre-trial.
It was
But
Article 2 as applied challenge.
yeah,
And I said at the time, well, he just pulled that out of his ass because no one knows what that is.
yeah. And what's really going to be, I mean, the more I kind of tried to think through this, I didn't have time to continue to read through the language and go back over it again. But the more it sort of just noodled over it, there's an entire mini trial here now,
Yeah. Yeah.
not just about immunity, but man, if Trump's defense team has enough time, they ought to have a motion in limine that's 50 pages long
Right.
with serialized items to be excluded.
Right.
And then because the opinion basically says that conduct or statements that are covered by the official acts immunity can't be used. So
Can't be
they're all
used at all.
subject.
Not only can he not be charged with them, but that they cannot be used as evidence of whatever it is they are going to be able to charge.
Yeah, so you're going to have an entire mini trial about what evidence is going to be used in the actual trial. You're going to have essentially a pre-vetting of everything that Smith intends to put before the jury.
Right, which that never
Yeah.
happens. But
Let,
presidential immunity isn't supposed to be happening either. So here we are.
let me put that in layman's terms. In one section, Roberts tied one of Smith's hands behind his back when he said, "You cannot use as evidence of the crime anything that happened that was within the core functions of the executive. We're not going to give you a chance to backdoor a a claim of criminal conduct that's
Hey,
based on."
I just saw. Hey, let me jump in. I just saw a note. Breaking news. Apparently, Trump's lawyers today filed a motion to vacate his convictions in New York based upon the immunity because all of the conduct took place while he was president.
Right.
Yeah. So on
That
the
may or
one
may
hand,
not work, but
yeah.
I would do it too if I were
Oh
them.
no, I agree. I
Throw a
agree.
monkey wrench in that case for sure.
So in trying to prove that the middle ground conduct was not worthy of immunity, Smith cannot use as evidence anything that happened or was said on the core functions of the president. That is, he can't use evidence of his attorney general and the DOJ officials telling him that there's no evidence of voter fraud. We can't find any evidence of voter fraud. That's what the J6 committee found. That's what the one of the key components of Smith's case, which is based on the assumption that Trump knew.
Right. Their proof that he knew was all these people told him
Yeah,
we didn't find it. Yeah.
he knew that there was no fraud in the election and he really lost. He knew that because his AG told him that. Well, basically, Roberts just said, you cannot use that.
And I really liked this part. And you can't he said Smith could not use basically motive type
That
evidence.
was the second thing. Yeah,
Yeah.
that was the other hand being tied behind his back
Yeah.
because you cannot talk about motive in this immunity analysis. So if he's got evidence of Trump's real motive, it doesn't come in.
According to him, according to
Yeah, see,
Smith. Right.
and that is the knife through Smith's own heart because that motive is where he wants to pour out his views of corrupt intent.
Right. That's
It's
his
like,
view of the law in
yeah,
general. You're right, it is. Yeah.
Uh,
So
you
we talked
guys,
about this weeks ago though that this is a problem in our current system. We've let creep into the law this idea that there's a pretext, that you did XYZ and you were legally entitled to do that, but you did it for a reason we don't like, and now that's criminal instead. This is
That
not good.
we talked we talked about this many times, and it
Yes.
goes back to the Mueller investigation and Trump firing Comey.
Right.
And you remember Weissman and the Mueller team wanted to indict Trump for obstruction of justice for firing Comey,
For firing the FBI director, which he had a legal right to do.
which is a core function
Right.
under this analysis. And Bill Barr, before he became AG, wrote a 12, 14 page, well thought out, well written opinion just on his own, sent it to the AG and to the Trump people before he became AG, uh, arguing that if you allow a prosecution of a sitting president based on a a, a criminal statute that is driven, and his guilt or innocence is driven by what he thought, what his motive was when he fired somebody, what his motive was when he did something that was perfectly otherwise lawful and constitutional, you have destroyed the executive branch.
Right.
And that's basically what Roberts said today.
Right. Now, tell us a little bit about what he said. I know folks were very interested in this issue about whether Trump had to be impeached first.
He rejected that argument. He said that uh, I forget exactly the reasoning, but he said impeachment is kind of as it's a entity among to itself
Right.
and has no relationship to whether a later prosecution, despite what Hamilton said in the Federalist Papers,
Right.
it the two are not connected.
Right. This is what I've been saying people all along. They're two different tools for two different purposes. So I was pleased with that part. But Ship, I know you wanted to talk about two particularly striking parts of the opinion. One having to do with the First Amendment issues and the statements and the speeches and so forth. So you want to talk about that for a second?
Yeah, that one caught me by surprise a little bit, and I think in just a sledgehammer to the side of the head, it probably took Smith by surprise as well. But basically, there's a line when Roberts is going through, the presumptively official conduct. He drew a great big wide net for uh, tweets or speeches or commentary by Trump while president on the basis that, a president's First Amendment rights, are sort of co-equal with his need to communicate to the country. There's probably no other individual with the need to communicate as significant as a sitting president. So he said, I think he used the words. I don't have the opinion in front of me. If somebody wants to look it up, he used the words comfortably within the outer limits of official presidential authority. So by drawing all of Trump's commentary while in office into the circle, he basically then said, so to overcome the presumption in order to be able to use any of that, it's not the prosecutor, the special prosecutor can't just grab the excerpts he likes. They all have to be considered in context of the speech or commentary as a whole. Well, I mean, there's probably 100 or 150 different, comments attributed to Trump in the text of the indictment, and each one of those is now going to have to be parsed on a comment by comment basis, taking into account the context of the entire speech. Um, and so
Oh, you mean they're not going to be able to leave out the peacefully part anymore?
yeah, exactly. Not going to be able to just cherry pick, the phrase or the one sentence and take it out of context. Um, which, I mean, that has been the lifeblood of the January 6th prosecutions. Is the government using all of its tools to get at social media and texting and Facebook and just taking out little snippets that somebody has said 3 months before the election, and then using it to say, "Oh, aha, there's your corrupt intent right there. You expressed it yourself in writing, to your mother." Um, but
Right.
this is again another aspect of this unbelievably complex and time-consuming mini trial that is going to have to take place before any actual trial.
Which drives me into the other point, which is we talked several times about what what's the scope, I guess I'll say, of what Judge Chutkan has to do here, because they're sending it back to her for findings. And so we debated whether or not she was going to be able to just look at what was charged in the indictment and apply whatever brand of immunity the court handed down against what Smith alleged, or if she was going to have to apply the new immunity understanding to, in reality, what actually happened to the facts that happened in the real world, not just what the prosecutor decided to put in the indictment. It seems clearly like they're saying she has to have an evidentiary hearing that encompasses the factual scenario that existed at the time, not just what Smith chose to put in the indictment. Do you
Right.
agree?
I
Yeah,
I agree, and I know Ship does too.
yeah. This goes back to the issue that I've championed since day one, is that the typical standard of review, which she adopted in writing, and the appeals court reaffirmed, the typical standard of review in a motion to dismiss is you accept the facts alleged in the indictment as true. And I had been saying, but you can't do that on an immunity claim, because an immunity
Right.
claim turns on what actually happened. It's
Right.
either immune or it isn't immune as a matter of fact. Well, both sides have a story to tell. If you allowed it to be done simply based on assuming the facts of the indictment as true, then you create an opportunity for a clever prosecutor to draft his way around immunity claims. Um, or an idiot prosecutor like Fonnie Willis, who simply says the defendant did unlawfully. Every
Right.
sentence
The
begins with
following
unlawfully.
things. Right. Yeah. Right.
Um, um, so yes, there's no question that these are contested factual issues, meaning each side's going to be heard, and it's going to be a battle of evidence as to what is the true nature of the conduct, what is the true nature of the statement in context, to determine whether or not this presumptive, whether it falls within the outer perimeters, and then if it does fall within, can the presumptive immunity be overcome? This is they have almost created a process that can't be accomplished.
Right. I agree. And in no time, quick, if they do attempt it, right, that is not going to be a fast set of hearings.
Ship, I got a question on that. Put your defense lawyer cap on. Um, the central premise of this whole prosecution is that Trump lost the election and he knew it, but he created this fabrication, this fraud that he really won. And
Don't make me lecture you on that like you did lecture me last night.
I'm not gonna no, but I'm just saying I, I this is the premise to my question. Uh, bear with me. That's how the indictment begins. That Trump knew he lost, but he and his conspirators created this this facade, this masquerade of a phony fraud claim that he really won, and it was all made up. I have sat and watched testimony at the DC disbarment hearing as to whether Jeff Clark should keep his law license or not. And I've read and seen parts of the video stream of the similar hearings they had in California over Eastman. And in both of those situations, those gentlemen put on a damn strong case that there was fraud in the election, that there was strong evidence that not all lawful votes were counted and a whole lot of unlawful votes were counted, which threw the whole thing up into a genuine dispute. So, to what extent does the issue of was this really a free and fair election come into play in this immunity analysis in the hearing?
I remember, Andy McCarthy raised this very issue when the indictment first came down and before it started, or after the indictment came down. And he said, the problem with the indictment as you read it is it's easy for Jack Smith to basically tell a one-sided story that only reflects what Trump was being told by one particular group of people. And that ignoring the proposition that it is almost a metaphysical certainty that the Trump defense is going to bring in another whole, a line of people who will say they were telling Trump exactly the opposite.
Well,
So
and then
he
he
was
was
getting
seeing the
information.
opposite on social media,
So he was getting conflicting information.
Right.
And how is it criminal intent to choose to believe one, not the other? You happen to believe the one that is in, that benefits your worldview. You discount the one that doesn't benefit your worldview, but doing one and not the other doesn't mean that your decision is reflects criminal intent or not.
But
So
apart from that, the real issue that this hearing is going to have to explore is whether those issues push this closer to core immunity, a core presidential function. That is,
Right. We're really going
his,
to get into the question that a lot of people have been asking, which is what are the duties of the president with respect to an election, whether he's the candidate or not?
well, doesn't the Constitution have some words to the effect of to see that the laws be faithfully executed?
Right. But then the
And
question is, okay, so but where does the president's responsibilities lie on the
well, okay,
amongst the
now
group of people who obviously do have responsibility for it? It's not
I
just the
don't.
president,
It
right?
was. It was. It was. I don't know if it was a spaces we did on the briefing or if it was after the hearing. But King made a very interesting point talking about the briefing. I remember maybe it was after the hearing. But he was talking about the briefing, and that was the discussion of the fact that the prosecutor and Judge Chutkan and the appellate court had ignored sort of the reverse image of Trump's claim for why it was perfectly within his responsibilities to see that the laws be faithfully executed, to pursue the claims that were being made about fraudulent elections as president and not simply as candidate.
As candidate, correct.
And that was because when you flip the image upside down, he's defending the rights of his supporters to have an accurate election, because if there was fraud, they had been injured by the fraud.
Right. Well, I mean, we have an entire section of the Department of Justice that this is what they do. And so I have not been able to understand how it is that the libs now have decided that the executive branch doesn't have anything to do with elections. How can that
But
fucking be?
Well, no, their argument is that they did that the elections, the Civil Rights Division, whatever that section is on elections, that they looked into the allegations and
Okay.
they found they were unfounded.
Yes. Right. But therefore, you can't make the argument that the president doesn't have any responsibilities in that regard. They want to argue both. That
Justice Roberts answered that question in the opinion today. He said that the head of the Civil Division, Jeff Clark, who was whose name is not, he's listed as a number in the indictment,
right.
who was telling Trump, look, there's evidence of fraud. We need to get an investigation going. And the AG, the AG and the other officials in the DOJ were telling Trump, no, we've looked at it. There's no fraud. It's a clean election. You lost. Roberts said today that it was within his core powers to fire the second group, the ones that were telling him, don't look any further, and hire the other guy who was saying, I've got evidence of fraud. Let me go get him. That why doesn't that and the evidence that we saw in these disbarment cases, why doesn't that settle the whole case? Why is this not a complete immunity based on core function? That is the effort to investigate and look at voter fraud and other unlawful votes being counted in the states. That's part of the DOJ's responsibility.
That's my point. But
Yeah.
these libs are like, well, the feds don't have any responsibility for that. Well, that's obviously not true. There's an entire division of the Department of Justice whose job it is to do that. You're saying that the Civil Rights Division is unlawful? Because they definitely don't want that to be the answer, right? It just never makes any sense when they're talking. But so I agree with you, King, that it seems like that kind of goes to a core issue of most of the case is if the president had the ability to look into that and do something about it, then how can anything he did in that regard be illegal? But that's the point of this presumption, right? I suppose you could say, well, you know, you still can't do being playing devil's advocate here, taking Jack Smith's part. You still can't do the quote unquote fake electors, right? Like even if you could get DOJ to look into it and whatever, you still can't create fraudulent documents to try to bamboozle the Congress. Now I don't believe that that's what happened, but that was one way of looking at it.
Well, that's where the context comes into play.
Yeah.
And Robert says, look at the context. The context was nobody was fooled that these people represent the real choice of the
Right.
voters.
I agree with you about that. We talked about that last night. I don't see
Yes,
how it's fraudulent. I just
it,
fraudulent means, deceptive in some way. I fail to see how it's deceptive. So, all right, but so King, I'm sorry. So the court answered our question. We said many times that we were hoping that they would, which is Judge Chutkin supposed to just look at the indictment, or is she supposed to look at what happened in the real world? Right. So people have asked a couple of questions they want us to answer about this decision. One of which is, what do we think the effect of this analysis by the court today will have on people like Jeff Clark? Right? Like, if the president has presidential immunity for being prosecuted for talking to his attorney general or another Department of Justice official, as Clark was at the time, doesn't that seem like it also means Clark has immunity for being on the receiving end of the president's presidential communications? What do we think about that? So it wouldn't be presidential immunity exactly, right? But is
I'm
there a
gonna.
derivative presidential immunity?
I'll tell you what. I'm gonna decline and defer. But, well, for this reason,
Yeah, I understand.
I don't know the facts of Jeff's disciplinary. I mean, he has been charged in any courtroom. He's got a disciplinary action ongoing in the District of Columbia.
He's charged in Georgia.
Oh well, that's right. But I think Georgia's going away because there's a line in there about, you know,
Well, that's the second issue. People want to know, does it affect the other cases? So let's talk
yeah,
about
yeah.
that in a minute. But just
Okay,
focusing
but
on the
well, the reason I
logic of
want to
it.
not commit myself one way or the other is I don't necessarily know exactly what the allegations of him are. He drafted a memo. I'm not sure he ever sent it. It was almost like writing the memo was enough. At least that's a
Yes.
odd. You know, they just found it on his computer. Um, but I know Jeff, and so I don't want to make any. I don't want to make
Okay.
any comment.
All right. So let's
I,
let
I,
King
I,
talk about it then.
yeah, he drafted a letter to go out under the DOJ's letterhead, signed by somebody high up in the DOJ. A letter to Secretary of State of Georgia. I'm not sure who else, but basically said we have evidence of fraud or
Issues. Right. Yeah.
irregularities. Uh, we think you need to investigate this. Uh, he, I think he commented on the possibility of the electors um, e- exploring. He suggested exploring different ways to get Georgia's view to Congress, considering the what he said was evidence of uh, fraud in the election, or not fraud, irregularities in the election. He uh, and he was put down vigorously by the other officials and higher ups in the DOJ, suggesting that it was a fraudulent letter. It misstated the facts, and uh,
Right. So
and
now
then
that's
they
a crime for a Department of Justice lawyer to have written a memo that misstated the facts. Uh-huh. Okay.
it's a
Sure.
crime in Georgia, a crime
Right.
in Georgia.
Right.
Okay, a a
Well,
a,
Clark
a,
is
a
obviously one of the unindicted co-conspirators in Trump's DC case.
yeah.
Right. He's not charged, but his
He's
conduct
not
is
charged in
considered part of the conspiracy.
he's charged in Georgia for violating a Georgia law
Right. Yeah.
for attempting to commit a fraud against the state of Georgia,
Right.
because it was only an attempt because the letter never got approved or
Right.
sent out. Trump
Right.
refused to sign it.
Right. Well, the
So
other thing is that in one of the indictments, I can't remember if it's DC or Georgia, the prosecutors allege that it's a problem that Clark went to meet with Trump after he was told not to by his supervisors. So now it's a crime for a Department of Justice official to meet with the President of the United States who's asked for the meeting because the people who are above him don't want him to take the meeting.
and the purpose of the meeting was to vet Jeff to be the
Right.
new
To potentially
AG,
become the new acting AG. Right.
acting AG after Trump, pissed off at the
Right.
current AG, fires him and appoints Jeff in his place. All of that is a crime in Georgia, according to Fannie Willis.
Right.
Uh,
Right.
there
Okay.
is
But so
there
let's
is
focus
no
on the two
way
questions. Oh,
there is
sorry.
no
Go ahead.
way any of that is not immune.
Right, I agree. So, but the question is really sort of a technical one. So Trump's the president. He has the presidential immunity. That's what they decided today, right? The president is a unique constitutional actor. I've said that over and over and over again my entire legal career, and people just seem to have trouble accepting this point. But that's basically what they said today. The president is a unique constitutional actor, and he is immune for his actions. They didn't say, and so are all the people that work with him and carry out his directives. right? Because they didn't have to decide that today. But doesn't it seem like if the president is immune for wanting to talk to Jeff Clark and wanting to talk to him about the letter and wanting to find out Jeff's opinion about whether we should investigate X, Y, and Z, doesn't it seem like Clark has to be immune too? I mean, maybe it's a different form of immunity, but
There's two aspects to it. One is it clearly established that whatever Jeff was doing was within the official functions of his office
right,
as an agent within the executive branch, and subject to responsible to the president, who had core authority under the Constitution to do what they were doing. So that one, it's in his official duties, and two, I can't imagine how it's not immune, particularly immune from prosecution by any
the
state.
state, right. Unless you buy the 11th Circuit's cockamamie notion that somehow the remand statute and immunity and whatever doesn't apply to former federal officials as opposed to current ones. But that's a whole story for another day. But the second issue that people want to know is whether or not the case applies. You've already alluded to it once here, King, whether it applies to the Florida and Georgia and New York cases. So let's take the easiest and work our way to the hardest. So it seems clear to me, straight out clear. Obviously, it applies to the Florida case. It's a federal case, right? To the extent that that indictment also alleges conduct that is official acts of the president, that's just going to be off the table in Florida, don't you guys think?
Uh,
The
with
problem the
a
problem is the operative
qualification.
yeah, the problem is the operative language of that indictment all revolves around keeping the documents, retaining the documents in Florida after a request was made to return them. And
Right,
that's post presidency. And then you have the obstruction counts involving, failing to comply with a grand jury subpoena and a false certification. That's post presidency. So I
okay, right,
don't think it
okay.
can extend to those.
Well, okay, but let's break it down. So it applies to that case legally. The question is, factually, is there anything that it actually matters for? Right, there's some facts in that case, if I remember the indictment right, of things that happened while Trump was still president. Not very
Right.
many.
The original shipment of a
Right,
lot of the records was done in the days leading up to the 20th. 3 or 4 days. They were loaded in a van or however, taken over to the plane or whatever the mechanism was. That
right,
happened the 18th or the 19th or the 20th. So, spiriting them away from the White House and to Florida happened while he was still president. So
right,
that's likely, but that's not. But I think that Smith recognized that would be a problem. So the statutes are all charged under the Espionage Act with retaining possession after
right,
they were
right. Not
after
taking, but keeping.
right.
Right. Yeah,
That, that,
exactly.
there's a twilight zone aspect of that case. Uh, Among the boxes at Mar-a-Lago when the raid, the search warrant happened, were, I forget the number, 15 or more boxes that were shipped there by GSA, the General
Right.
Services Administration, from a warehouse in Virginia. They had packed them up at the White House while Trump was still president.
Right. Earlier. Mm-hmm.
And earlier, the government, kept them in a warehouse in Virginia. And then in September 2021, they shipped them to Mar-a-Lago. As nobody indexed them, nobody went through them, but just boxes of records. And those boxes with the records and possibly some classified stuff in it. were shipped there by the GSA, having packed them up when Trump was still president, and probably never really looked at by
Right.
anybody in Florida. What do you do with that?
Right. So I think we're all on the same page that legally this is a binding case from the Supreme Court. It binds Judge Cannon in her case. Whether it is going to have any force or effect in her case is it's sort of like maybe on the margins, on the edges in that case because of the facts. Are we all agreed on that?
Yes.
So that's Florida. That to me, that's the easiest case. The one that's slightly harder, but I still don't think is hard, is Georgia, because there he's kind of straight up charged with all the stuff that Roberts has just said you really can't charge the president with. This, right?
It's worse than that. I think there's a line, and again, I don't have it. There's a line in the opinion that makes reference to, just because conduct violates a general criminal prohibition doesn't mean it's not official
Right.
conduct.
Exactly.
And actually I think I screenshotted that early this morning when I was first going through it, and then put a little note on it. Hey, Fonny, I think he's talking to you.
I thought so too. Several times I'm like, yeah, this is them trying to communicate to pretty much any prosecutor who's listening that just because technically you can fit this into the elements of one of your statutes doesn't mean you can go for it. So don't.
And that's an interesting omission. At least I didn't see it dealt with in any significant way. There was a lot of
In the coverage today. Yeah,
well,
right.
but there was a lot of, remember back in the hearing, or in the oral argument, there was a lot of discussion about what do we do about these rogue state prosecutors. We
Right.
don't have the safeguards of the federal grand jury and the
Right.
professionalism of the Department of Justice. We got this. What do we do about those guys?
Right.
And this was, but that subject I didn't see overtly covered, but it was almost like this was the little Easter egg there, that just because it violates just because you think it violates some crazy Georgia statute, doesn't mean you get to file a criminal complaint in the state of Georgia.
Right. Right. So I expect his lawyers there to cite this case and ask for the case down there to be dismissed. But I mean, given the posture of it, do we think they'll do that now or wait or what? King, what's your feeling about how that's going?
Right now, the case as to Trump and most of the other defendants, or not, or at least half of the other defendants, is stayed because it's in the Court of Appeals on whether Fannie Willis should be disqualified.
Right.
There are a handful of defendants who are not part of that, and the trial judge, has declined to stay the case as to them. One of those who did not move to disqualify the DA, Missy Hampton, I think's her name. She asked her case to be stayed. Judge denied it. She took it to the Court of Appeals and got a stay from them.
Okay.
So if any defendant, I think, wants to be stayed, can get stayed, pending the resolution of the disqualification motion, which won't be decided until this fall at the earliest.
So as a
Uh,
practical matter, what do you guys think? Would you file that motion now or would you just wait?
I just wait.
Bill, what do you think?
Yeah, yeah. Let this sort of play out a little bit first.
Right. So, okay, so that's Georgia. So it is going to apply to Georgia. It doesn't matter that that's a state case. The Supreme Court says the president has immunity for X, Y, and Z. That's applies to everybody in terms of it's the law of the land. So it doesn't
Yeah,
matter that it's state versus federal.
and now imagine the kind of immunity hearing to be conducted in that courtroom, given what we saw earlier.
Right. Yes.
And it'll all be on, and it'll all be
It'll
online.
all be on TV. Oh, that'll be fucking crazy. But okay. Well, all right. So then that leaves us with legally what I think is the hardest case, which is Alvin Bragg's case. Now, Bill, you said Trump's lawyers, while we've been talking, they have filed a motion to, or was it
Yeah.
in Erdogan's
A
case
little,
that they filed?
no, a little bird tweeted it in my
Oh,
ear that
oh,
that they had moved late this afternoon to vacate. Well, I'm going to
oh,
guess it's the criminal case because sentencing's in 10 days. So you want to throw a wrench into the sentencing, you roll this grenade into the courtroom, and
right.
everybody watches the
Yeah, if
news
at all
feed down.
possible.
It's like,
Yeah,
because they can also raise the Erlinger case, the Supreme
right.
Court's
That we talked about
reaffirmation
last
of the
night.
need
Go
for,
ahead.
yeah, we talked about last night, that's now come out since the verdict. um, so I think Judge Marchand's got
Right,
some things he's going to have to think about.
The
right.
theory, if I recall, uh, they've raised the immunity before and it got thrown out. But this was before the Supreme Court opinion,
Yes.
obviously. But the theory is everything that Trump is accused of doing that violated the New York false book business records charges happened when he was president, and it would not have happened but for his being
Having run for and become the president.
having
Okay.
because as president he uh, he wears two hats, his individual hat and president hat, and he's required to basically devote all his time, energy, and resources to being president. So he has to rely on an outside person, a lawyer, to handle his personal stuff. And so when he's signing checks to Mr. Cohen, it's part of his official duties because he can't do that. He can't withdraw from his position as president to go handle those records personally. He has to rely on somebody else to do that. So that's the check writing process is part of those quote official duties. That's a stretch,
Yeah, I'm not buying that at
but that's what
all.
they argued. Mm.
Okay, they'll lose on that, but it may be, Chip, your point that it doesn't matter because all they're trying to do is get Judge Marchand to focus on that and have to grapple with it and make some rulings and put off the sentencing hearing, which is currently set for July 11.
Right. And and that gives them some time, assuming that he does push it back.
Right.
It gives them some time to marshal some of these other arguments, in support. I mean, I don't know I don't know exactly how the criminal procedure works in New York, but I would assume you file a motion for new
Nobody seems
trial.
to know.
You file a motion for new trial before you get sentenced. um, and
Right.
and they've got, now they've got, the Erlinger gives them another bullet. I mean, he just absolutely whiffed on not defining willfully. If he was going to use the federal statute, whether he should have or not, he has to define he has to, instruct on the appropriate, mens rea. Um,
Right.
and he did.
Bill, explain to folks who maybe weren't listening to us last night why Erlinger, which is the Supreme Court case that they decided yesterday, why that would apply to Trump's case in New
Okay,
York.
well, just give maybe the dime store version. But Erlinger was
Yeah.
a Supreme Court decision involving the Armed Career Criminal Act. Um, an Armed Career Criminal Act was for repeat violent offenders. Erlinger was convicted of being a felon in possession of a firearm. Then, after the jury convicted him, that exposed him to a potential maximum sentence of 10 years. after the jury convicted him, as part of the sentencing process, the judge found that he had committed 3 prior uh, violent federal or state felonies. And based on the finding of 3 or more, declared him an armed career criminal and sentenced him to a mandatory minimum of 15 years. So his potential maximum was no longer applicable based on the jury's verdict, which was 10. He now had a mandatory 15 based on the judge's finding. This has been an issue that has percolated around on a variety of federal statutes that laid out the responsibilities for the judge at sentencing, and the question came down to whether or not the judge was required to make factual findings in order to trigger the ACCA and impose the mandatory minimum 15 years. And the answer to that was yes, because the question of whether or not he had 3 prior felonies in some instances turned on the specific acts or the nature of those prior crimes, because sometimes
You said the judge. I think you meant the jury. So the question was whether the fact that it was 3 of them had to be found by a jury instead of the
yeah, instead
judge.
of the judge. And in this case, it turned out that the defense wanted to argue that he had been convicted of 2 or more felonies as part of the same episode. And the Armed Career Criminal Act is clearly designed for 3 separate episodes of felonious conduct, not one episode that produces 3 felonies. So that became a factual inquiry, a factual question. What were the nature of the crimes and the convictions and the underlying cases? And the Supreme Court said that the accepted practice of having the judge determine those, because they increased the defendant's maximum sentence, was unconstitutional. 24 years ago, in a case called Apprendi versus New Jersey, the Supreme Court said any fact that increases a defendant's potential maximum sentence has to be found by the jury unanimously on a proof beyond a reasonable doubt standard, and not
Because you
by the judge in some sentencing hearing
have
following a
amendment
jury's
to be
verdict.
tried.
Right.
Right.
So this
Okay.
now
So how is
applies.
that going to?
Okay, so in New York, the problem in the New York case is that Trump was charged with misdemeanors. However, the statute in the misdemeanor statute says that the crime can be elevated to a felony if the misdemeanor was committed for the purpose of covering up some second crime. And so the New York DA alleged that the second crime being covered up was this conspiracy to unlawfully promote a candidate for office, shorthand version. And the conspiracy to a conspiracy to unlawfully promote a candidate, the judge said, and the DA argued, well, we don't really have to be specific or unanimous as to what was unlawful, just that there was something unlawful in the conspiracy.
Right. Take your pick as to how
Right,
you committed this campaign
right,
violation.
right.
Right.
But so that sort of runs, while Erlinger is not perfect in that respect, it does reinforce the proposition. In Trump's case, it changed his misdemeanor into a felony based on a less than unanimous jury verdict as to a particular issue. And so that calls into question what the judge in New York allowed to do, which I think Leslie called it accurately and probably the best description, the verdict by buffet. You pick which crime you think you're most convinced of, and as long as everybody picks something, then there's a verdict.
Right.
So they can
it would
raise,
be
they can
pretty
make an argument
usual.
based on that. Good.
Right. It would be pretty usual with a new Supreme Court case coming down for lawyers to brief a judge and say, this new
Okay,
stuff you've already decided on based on this new precedent. So that's not at all uncommon. It shows the trend of the law, right? It shows the trend of the law as we've discussed, which is that more things have to be decided by the jury and more unanimously.
Correct. Well, under the
Chip,
circumstance,
can you hear?
where you are cutting in and out. Can you hear me?
Yeah, I hear you clearly.
Okay, you're cutting in and out, so that might have been when you weren't hearing me. Um,
Yeah, I moved, so let me move again.
yeah. So yeah, not only do more things have to be decided by the jury unanimously, but particularly on an issue that changes the sentence from a misdemeanor 1 year or less than a year, to a felony, which in this particular instance was up to 4 years. That, I think, is
Right.
the kicker. That's
Yeah,
the one that's
I
really
agree.
going to, be the irritation here, to not step back and say, I need, for the judge to not step back and say, I need to consider this in light of what the Supreme Court has just said.
Right. So that might delay that. Now, do we think that would be a good thing or a bad
Well, I'm
thing?
kind
Let's say
if
Erdogan
you if
that and
yeah,
he
you
sets
are
the sentence.
okay, Leslie, can you hear me?
Yeah.
Leslie. Okay, you are cutting in and out, and you're not hearing me when I'm talking because you just continue as if I'm not even talking. So I think,
You're right. I'm not hearing you.
yeah, so you're cutting in and
Let me
out
go back to where I was in the house. Yeah, new house. I haven't figured out where the coverage is good and where it's
where the
not.
dead spots are, right?
Yeah,
So,
exactly.
yeah. So I think,
Can you hear me better here?
I can hear you. Can you hear me?
Yep, I hear you clearly.
Okay. I think, if you were going to be Machiavellian about it, you might say that to avoid the problem, Merchan goes forward with the sentencing but doesn't impose any jail time, and sort of takes this,
Right, that's what I expect them to do
yeah,
anyway. But yeah, go ahead.
take the sting out of the unconstitutional process and just say, well, just like we'll leave the rest of it to the appeals court. But Trump remains branded a convicted felon.
In New
Yeah.
York. Right.
Politically, I'm of the view that the best thing that can happen to Trump is he gets sentenced to jail.
Well, it might not be the best thing for the nation, but you might be right that politically that might help him in a perverse way. Hopefully, we will not cross that bridge, you guys.
Speaking of something in a perverse way, you know how it has become, the standard accepted narrative on the progressive Democratic side of the aisle that Trump's some element of Trump's followers are a bunch of crazed wackos that react to the things he says and act in unpredictable, sometimes violent ways in response, even if he doesn't really mean for that to happen. He just, his dog whistles send people off to do things at what they think is his bidding, right? What the fuck?
Okay, yeah,
What about
that's one way of looking at it.
what about all of the commentary today online about,
Yeah,
well, just authorize Joe Biden to, have SEAL Team 6 go kill Donald Trump?
right. Or murder a bunch of these
Yeah,
justices,
how
right?
many
And
times now obviously
what?
they're being, they're being sarcastic, but they got some whack job crazies on their side too, like the guy that shot up the congressional
Well,
baseball team.
I was gonna say they've got some whack job crazies who actually took shots at folks. So yeah, I know, but they're just not responsible at all, and that's all there is to it. Well, okay, so in terms of New York's case, this case today from the Supreme Court probably doesn't apply. I had said to someone earlier today, we'd have to look at it really, really closely, right? Is there an argument that some of the conduct for which he was convicted was arguably immune? And if I were his lawyer, I would comb back through the indictment and the proof at trial and figure out, could you make that argument? Because you might be able to get him a new trial
Well,
based on
yeah,
that.
but
But
it's almost easy in this sense that the operative the facts of the crimes was basically downloading Michael Cohen's invoices on a monthly basis for a
Right.
year into the Trump business
Right.
records and writing Michael Cohen a check. Those are the two criminal acts. Everything else was
Right.
just nonsense,
Right.
unnecessary. Um,
Red Stormy wanted it or she
yeah,
didn't want
yeah,
it. Right.
yeah.
Okay.
So now those all happen while he's in office because the payments don't start until February
Right.
2017. I think the
Right.
first one is for two
So
months.
there's an argument there, and I would really, if it was my case, I would, diligently pursue that. But I'm not sure off the top
It
that
gets there,
there's
right?
actually anything to be had there. So legally, does it apply to the case in New York? Legally, yes, because as a ruling from the Supreme Court, the highest court in the land, it applies to any prosecution, federal or criminal, against a former president. But probably there's just no good argument that anything that was alleged in Bragg's case is on the official side as opposed to the personal side. So, all right. People also wanted to know, of course, now what happens in Judge Chutkan's courtroom. So, did you see, Ship? I tagged you in a tweet about what is that guy's name? He had a whole
Oh,
timeline set out where somehow the
Ryan
case
Goodman.
was.
That guy's just a complete
Oh
nutball.
my.
He also had one.
I was
He
like,
had a comment yesterday about, well, Fisher only applies to 5.6% of the January 6th defendants.
oh my God. All right. Well, I mean, he's not taking into account Chutkin's statement that she's going to give Trump's lawyers 88 days for pretrial prep,
Well,
right? Do you think
I
there's?
think I
Go
think
ahead.
her intent before she saw this opinion, I think her intent was to jam everything the Supreme Court said she
Into
had to
that
do
88
in
days.
those 88
Yeah.
days, and
All
schedule the
right. So let me
exams.
ask you this first. Yeah. Let me ask you guys this first. King, you too. Do you think she'll go back on the 88 days? Because I think probably not.
My view is
Like, she won't say, oh, I'm going to do 50 days
my
instead.
view is I don't care what she says about when the ultimate trial happens. I think the length of this trial, this mini evidentiary hearing on
Right.
immunity issues, is going to snowball.
Right. It's just going to
It's
overtake
going
it.
to
But
overtake
but
everything.
first, yeah, yeah. But I just am interested in this idea first of, I don't think she'll go back on the 88 days that she committed to. Do you guys agree with that?
I think it's moot because let's say she
Right.
starts that, I'll call it the Roberts mini hearing next week or the week after next. It's going to go on for a month or longer.
Right.
She's
Right.
going to write an opinion. She's going to have briefs. She's going to write an opinion. So we're looking at 2-3 months of that, and then Trump appeals.
Right. Okay, but I'm trying to get to a different point, King, which is people like this Ryan Goodman, they're not even taking into account that she said she's going to give him 88 days. There's just no way that a trial's going to happen in August or September, right?
No, no way.
Right. She's going to give the Trump people their 88 days. That only, as Ship told us yesterday, that takes you to October 6th. Okay. So that still gives you another month. But so people who are saying that trial's going to happen in August or September, like they just don't know what they're talking about because they apparently don't know that Judge Chutkan has said she's going to give Trump's lawyers 88 days of pretrial prep time from when she gets the case back, which hasn't even happened yet. So that's one issue. But the second issue, King's one you're going to, which is even if she tries to squeeze it all into her 88 days, that's not going to happen either. Right?
No, it's impossible. Because
Right.
Trump has another appeal, which will put everything on hold pending the appeal. Uh, it, if I were not a Jack Smith style uh, prosecutor, partisan type prosecutor, and my whole job was to seek justice, I would seriously consider dropping this case.
Yeah, I agree. Based on this ruling today, that is what they should do. I mean, they should be getting the hint that you really shouldn't have brought this case in the first place. They're probably not going to take that hint. Oh, we lost ship. Um, but they should. So, well, King, let me ask you: do you think um, they'll forget about the appeal for a second? Do you think Judge Chutkan will be able to get all of that stuff done that is basically following Roberts's roadmap today? Get it done before the election anyway?
Yeah, I've read some posts indicating that, well, we can't get doesn't look like we can get the criminal trial we hope for, so we can get maybe a Judge Chutkan led show trial before election.
Right. I saw those tweets too. I thought it was interesting that they were basically conceding they can't get to the jury before the
Right.
election.
So we're going to put it all out there in Judge Chutkan's court. That is not very effective. Uh,
It's not on TV
it's
for
not
one
on
thing.
TV, and it's a lot of the nuances are going to get lost. You're going to have cross examination for the first time in this. You didn't have that in January 6th. You didn't have that
Right.
in up to now with the
Well, and it's your point from earlier too that they'll be able to put on potentially some evidence like Eastman did, like Jeff Clark's lawyers did for him, of yeah, well, but actually there were problems in the various places with the
absolutely,
electoral process.
they could easily that could blow up at their faces easily before
Right.
the election. That's why that's one of the reasons. If I'm Jack Smith, if somebody other than him who was rational, uh, I would seriously think about dropping this case.
Just getting it over with. Do what the Mueller people did and just take your swallow your medicine and have them to dismiss the
Well,
case.
here's what I would do if this was a purely Machiavellian politics play. I was Garland. I would say dismiss the DC case, dismiss the Espionage Act counts on the Florida case, get
Right.
rid of all of the classified information nonsense, and move forward on just the obstruction.
Obstruction in Florida. Right. That's the only thing that has legs out of all of
And it's
this
simple.
mess.
It's
That's the only thing that has ever
a
had
1 week
legs.
trial.
Yeah.
Yep, I agree.
So what we talked last night about one option Smith might have would be to skinny down his indictment to only stuff that nobody could argue was official.
Can't do it
Now,
now.
is there enough of
No,
that? You don't think he can do it now? All right,
that's
Chip,
I
explain
thought
why
that
not.
was last night I said I'd written a Substack article yesterday where I sort of you know applying Fisher and anticipating immunity, thinking that if they really wanted to try to get to trial in early October, just take a hatchet to the complaint, get rid of the Department of Justice stuff, get rid of everything that was even quasi objectionable, and just jam to trial on the fake elector scheme and nothing else. But now, you know, it's like I said, the problem is there's going to be a mini trial on what's admissible,
Right.
and that's going to pervade pretty much everything, starting with all of the Trump commentary at various points in time that's reflected in the indictment, and might be other commentary in the discovery that they propose to use. It's an extraordinarily odd circumstance where as a from the practitioner's point of view, the 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 statements of a party opponent are immune. You know?
Right. Yeah. Normally, you guys, the statements that the person on trial made can come into the trial, even if they don't testify, because things that you say that are against your own interests can come in. But if they're immune, then they can't. And prosecutors are not used to that. They're used to using the defendant's words against them.
Right, but all of that is going to be, it's going to be excluded on presidential immunity grounds to the extent that his
Right.
comments are within the broad horizons of official conduct.
And then the ones that aren't are arguably protected by the First Amendment, which is slightly handled slightly differently at trial, right? So it's not as strong a defense as immunity, but you cannot be prosecuted for your First Amendment views, but things that you say can be used as proof of other things, often intent or motive. But based on what Roberts did today, I think that's going to be difficult for the government too.
Yeah, so I think it's there's what I thought might be an opportunity to skinny it down and have a narrower focus, get past what I expected the immunity decision to be, at least with Chutkan's approval. That didn't mean it
Yeah,
was probably going to be. We talked about last night that regardless of what her ultimate order was, that they would probably seek to appeal it, and
right.
that would require another trip through the circuit unless it was dismissed, outright. But the what Roberts put in the opinion today about the nature of the disputes that need to be resolved pretrial, and all that does, if you think about it, all he's doing is saying you need to have the evidentiary hearing that you should have had before you brought it to us, meaning that
Right.
once that evidentiary hearing is actually had, it can be brought back to us.
Right. He was very clear about that. He was saying that this court is a court of review, not a court of, figuring stuff out in the first instance. He was obviously annoyed at sort of the posture that the case came before
Well,
them. And as he should have been.
well, he doesn't say this, but defense lawyers like we are, the back of your mind, you're thinking, okay, we're going to have this pretrial evidentiary hearing that could last for some time. Judge Chutkan is going to have to make a decision, and it's not going to be a one-liner. She's got to write an opinion.
Right.
And Trump, whatever she says, Trump is going to be able to take some of it up on appeal, first to the D.C. Circuit, and then to the Supreme Court. And what if he gets elected in the meantime?
In the meantime.
Okay.
Right. Yeah.
Justice Roberts told him that it's in his core presidential responsibilities to hire and fire people on the prosecution side
Justice Department.
of the
Yeah.
executive branch. So he
Right.
first day in office, he fires Smith, he fires Garland, he appoints somebody else, and he gets the case dismissed.
Right. Well, Garland will have
Well,
resigned. He'll go out with Biden's people. But yeah, basically all new DOJ people come in. Right.
he's going to fire everybody who had a finger on that case, and it goes away. So
Right. But what's going to be interesting will be if Trump does not win the election in
yeah,
November.
but exactly. But listen, but if he does,
Yeah.
it goes away.
Yeah, it'll be interesting in a different way. It will go away. I would make it go away. I will say I'm not shy about that. If I were in his shoes and I got elected, the very first thing I would do is order those cases dismissed.
So what does that do if you're in Smith's shoes and Garland's shoes?
Yeah, what to do? Yeah.
Do you really want to make this an issue in the election?
Well, Smith has shown every propensity for always making the wrong decision.
Yeah.
So, and doing the most aggressive, stupid ass thing that's available to hand. So, he probably will try to keep going forward. But it's just he's swimming upstream at this point. So, we think no trial in DC.
No trial in
Am I right?
D.C. And there's another possible reason.
Yep, go ahead.
Justice Thomas.
Oh, yes, I knew. As soon as I saw that, I thought, oh, King's going to have some stuff to say about this. So if you weren't listening to us last night, King was raising that Judge Cannon might rule on whether or not Jack Smith was properly appointed in the first place in her case. Trump's lawyers have not yet raised that issue in front of Judge Chutkan, which was probably good tactics at this point, I would say. They have raised it in front of Judge Cannon, and she held her hearing on it, but she hasn't ruled on it yet. Right? So, but Justice Thomas decided to talk about that today. So tell us about that, King.
Yeah. Even though President Trump's team did not raise it in the D.C. District Court or the Court of Appeals or the Supreme Court, former Attorney General Ed Meese, later joined by what's his name, the other AG, escapes me right now. I'm getting the Biden disease. But the two former AGs raised the issue of whether Smith, special counsel, was unlawfully appointed because
And is being
he was
paid.
not
Right.
appointed by the president and confirmed by the Senate, even though he held an office basically equivalent to or higher than a typical U.S. attorney who is appointed by the president and confirmed by the Senate. That's what the Constitution says must happen, as do all federal officers.
That pesky Constitution
And
again.
the only argument against that is that Congress has passed a law allowing, in this case, the Attorney General to appoint somebody to an inferior office. But Justice Thomas wrote a concurrence today that said all the laws that A.G. Garland has cited and Smith has cited in there to support the appointment don't apply. So we're back to the Constitution. and
That pesky
and
Constitution.
and Justice Thomas basically directed the lower court or courts to address this issue when it comes back. I want Judge Chutkan to determine whether or not Smith is lawfully appointed and whether he is being paid with a constitutional congressional appropriation.
Appropriation. Right. Now he can say that. He can't
He
really
can't
order it
order
because he's
it, but
not in the
he would
majority.
like
But
very strongly. He,
he would really like to know
and
what she thinks about that.
but here's the thing, to quote our president. Here's the thing: the that exact same issue was raised by both Trump and Attorney General Meese in Judge Cannon's court in Florida. She heard a day and a half of arguments on it a week or so ago, and she now is sitting on it and writing her opinion and trying to decide the issue. Should I kick Smith off the case or dismiss the case because Smith doesn't have lawful authority to bring this case to the grand jury? Even he's not a, a lawfully appointed officer of the United States, and she has to decide that issue. It's in her lap, and now she gets this concurring opinion from Justice Thomas that, in effect, writes her opinion.
Right. He says, I don't think so.
And he went into it's a really well written opinion about why Smith is not lawfully appointed constitutionally. Goes through the history of the Constitution, goes back through the founding fathers and what they thought on the issue, why they have this clause in the Constitution, and there it is staring. If she bothers to read it, there it is staring her in the face. Is an opinion she could sign her name to throw out the whole case because Jack Smith is unlawfully appointed.
All right. So do we think that will
Hang on,
happen?
let me add one factor that I took a real close look at his opinion, and I realized it took me about 20 minutes to figure it out. But I realized if you go through and you isolate every eighth letter in its opinion and you spell it out, it says, "Hey Joe, remember the 1989 confirmation hearing? I do. Signed, Clarence."
You guys. Okay. So do we think Eileen will go there and throw Smith off the
How
case?
how could
He's
she
having a
not?
really rough day
I,
already. I
How could she
I
know.
think she
not?
has to. She
She's gonna disagree. She's gonna write an opinion that disagrees with the justice of the Supreme Court,
With one of the nine. Yeah.
who's taken the time to draft a concurring opinion saying this guy's got no business doing what Garland's got him doing. She's
not
got to.
not only that, but nobody else on the court addressed it.
Right. Well, they didn't want to. They're all
They
like,
Well,
they, they
that's
didn't want
like
to touch it.
okay,
the turd in the punch
yeah,
bowl. They don't want to go
no,
there.
but let's be fair. Thomas asked the question in the oral argument, "Have you raised
He
that?"
did.
And Trump's attorney
He
said,
did.
"We have not raised it here. We have raised it in Florida." So I think for the balance of the court, it's like it's not before this court. So Thomas,
Right.
Thomas, was writing out of school, but that's why I
Yes.
looked for every eighth letter. I came up with what I came up with.
Uh,
If you want to know why,
You look at the first letter of each line of the opinion.
now, now I haven't checked this, but
Oh, God.
somebody posted that the 11th Circuit is assigned to Justice Thomas. So if writs go up to the 11th Circuit and some action by the Supreme Court is called for,
He
he
gets it
gets it
first. Yeah.
first, and that's where Judge Cannon resides
yeah.
in the
Right.
11th
Okay,
Circuit.
Yeah.
now think about this. Think about this. Let's think about the timeline and the time of the year. Let's say she follows his lead and DQ Smith, and as a result, let's say she takes the step of dismissing the indictment as as being ignores the de facto officer doctrine, and the government takes that to the 11th Circuit, and the 11th Circuit reverses her, and then Trump takes the reversal to Clarence Thomas in July, and the court doesn't come back into session until October. Can he just put in place a stay on his own pending further court review during a time period when the court's not in session? How
He,
how
Yeah, he can as a temporary matter, but then what they usually do is they refer it because they rule on stuff even when they're not in session all the time.
but he can
Um,
stay it until they
yes,
get
himself.
together
Yep.
and
Yeah.
decide it. He absolutely can.
Yeah. And probably would for at least a few days until they
and,
can decide what to do
and
collectively.
if he did, let's say, okay, we talked about this last night. One district judge's opinion doesn't have any influence on another district judge's opinion. But what if the 11th Circuit reverses? Then he stays it. Now, what does Judge Chutkan do?
Yeah, that's a thornier problem for her if the Supremes do anything with it. Yeah. Yeah, then she has to really seriously take that into account in terms of her own, choices. Poor Jack. Don't we feel bad for
No,
him?
no, we don't. No, he's a uniquely deplorable
Yes,
individual from the Department
divisive.
of Justice. Always
Right.
has been.
Yeah. Yeah, exactly. Him and Andrew Weissman are the worst of the worst. Okay, so So we've talked about the majority and we've talked about Justice Thomas. And so we should talk a little bit about the dissents from the liberal justices before we go. So thoughts, comments? It was the case we didn't really even say was basically 5 plus Amy Coney Barrett mostly, and then Kagan Sotomayor and Ketanji Brown Jackson as the dissenters. Do we want to say anything about Justice Barrett's
Yeah, look,
position?
this builds on something else that I had read elsewhere. You know, she seems to be to a lesser degree, but in the same mode as Roberts, of preferring avoidance when possible. The commentary I heard yesterday was talking about the militant standing brigade. Like whenever they don't want to deal with something, they find a way. It's odd that whenever they want to deal with an issue, states always seem to have standing to press that issue. But when they don't want to deal with an issue, it's just amazing how often the litigants before them just lack standing to support the court's jurisdiction to deal with the issue. Well, as I read her, and all I could really do was glance at it. It was too long for me to really want to dig into it with the time I had available. But I kind of read her opinion as more this is an avoidance issue. We don't have to deal with these issues to the extent that the court is. I don't, she joined them in the outcome, but she did not join some of what she specifically didn't join 3B. What was 3B?
It was related to her question at the argument about whether or not some of these problems could be solved with instructions to the jury or findings by the jury, which in light of the fact we're talking about an immunity issue, I think is complete nonsense.
Well, okay, so
this was her point of disagreement with them.
Okay, so I don't fully appreciate what the extent of her concurrence was because I didn't read it that closely, but I saw just enough
You
lines.
used the word
Avoidance.
So yeah, exactly. She does tend to go that way. I agree with you, but you use the word odd, and I think that's the best word for her. There is something very odd about
It's an academics approach. It's not rooted in the actual way things work in the courtroom.
Practice of law.
And that goes, and that's also this reliance, that I was listening to a podcast talking about, the how there are, it's Roberts, Comey Barrett, and to a large degree Kavanaugh, who sort of
sometimes
have created this anti-standing group that the liberals are happy to jump in and join them if it means an issue that they don't want the conservative majority to rule against them on. And the three in the middle, it's like, and this was the description was, it's a 3-3-3 court. You got 3 conservatives, 3 kind of avoidance prefers, and then the 3 liberals. Well,
and actually, I think it's 1, 2, 3, and 3 because you've got Gorsuch over here as the lone libertarian.
But the way to not have a conservative majority rammed down the throat of the liberals on over and over again is for 2 or 3 of the standing brigade to simply join with them and saying, "Oh, well, this is not ripe, or these litigants don't have standing, so we're not going to resolve this issue now." And they dodge.
Yeah, and I think that that's true. Yeah, I think that that's true. She's in that group, but she also does her own thing, right? She's joined the liberals in a couple of different cases where it's like she's just gone off on her own little tangent that, isn't really what the case is about. It's like she feels compelled to always see issues that other people don't see, and I'm like, yeah, that's because that issue doesn't happen to be in this case.
What was really interesting in both this case and Fisher is the silence of Kagan.
Yes. Yeah, because probably in a way she doesn't disagree with the majority opinion.
But she joins Sotomayor's rant, which has,
Yeah.
But
that rant I think is not super appropriate. As you pointed out when we talked about it earlier, there's it's kind of thin on citation. It's more like just I'm unhappy with what happened here.
Yeah, she was using waterproof paper as she cried.
Right. That was one of the more horrifying things to me that happened recently was for a Supreme Court justice to say, that some of the times she just goes back to her chambers and cries. I just thought, are you fucking kidding me? Right? This is as a woman lawyer, I just think, what is wrong with you that you would say things like that? You're just making it look like what women aren't tough enough to be lawyers or women can't be, as logical or as dispassionate as men are. It's one thing to be passionate about the things that you believe in, but to say, oh, you just go back to your chambers and cry. I just thought that is fucking
If
weak.
somebody, and I don't remember, I think it had to be a conservative commentator on X today, pulled up, Lawrence Tribe's old letter that about her when she was on
About
the
her.
Second Circuit,
Yes, I saw that too.
and posted, apparently
Right.
Lawrence Tribe was right.
Yeah, seriously. I think that was FOIA fans uh, on X. So, do we want to say anything else about the dissents? I mean, it's basically wailing and gnashing of teeth. You've turned the president into a king, and all is
Well, I think
lost.
there's the interesting juxtaposition there of the point of view is that on more than one occasion, maybe not more than two, Roberts went out of his way to say, look, we're not focused on the exigencies of the moment. We're focused on how these rules will come into play, in years and decades in the future. And the dissents were all about Donald Trump.
Yeah,
Right. They don't care
I
about
mean,
that.
even more than that, Roberts made a major point about we cannot get this country in a position where whenever a new administration comes in, the first thing they do is prosecute the prior president, and you're going to get prosecution after prosecution every time somebody leaves the office, and that would destroy us.
Well, except for the federal grand juries protecting the courtroom doors.
Right. What I don't understand, I continue to not be able to process, and I think this is a function of my generation. I'm Gen X, right? I don't understand how these liberals don't see how terribly problematic that is. It's the banana republic scenario, right? We're not a banana republic. We've prided ourselves for centuries on that fact.
Well,
And
it's
now they're just prepared to throw all of this out the
no,
window because they're so mad at the orange man
yeah, it's
bad.
it is unique to the singular evilness of Donald Trump. That
Right.
once Trump passes from the scene, they'll just call Republicans Hitler. They won't actually really mean that Republicans are the equivalent of Hitler. Yeah, we called George Bush Hitler, and we even called Mitt Romney Hitler, and
Right.
we called Bob Dole Hitler. But we didn't really mean that. That was just
Bob
yeah,
Dole, who was
yeah,
injured in the service of his country
fighting
fighting
against
Nazis
Hitler,
in
right?
Italy.
So that,
Right.
that was just rhetorical. But Donald Trump, yeah, he is Hitler. And once we're rid of him, we'll just go back to calling you Hitler, but not really meaning it.
Mm. Mm-mm. Okay. All right. Well, it came out the way we said it was going to, you guys. And I think this is overall a good thing for the country. These libs can be as upset as they want today. And I enjoyed mocking them and making fun of them today and writing limericks. Did you guys read my limerick?
I did.
Uh,
Um,
I love
Yeah.
limericks.
almost motivated me to open up a bottle of Guinness Stout.
So, but taking things seriously here for a minute, this was the right decision for the country, which is what Roberts is trying to tell these knuckleheads, and they're just not listening.
Yeah, going back to the political angle, like I said, if from the legal perspective, legal angle, the one path forward is probably to abandon DC, because it's just a
It's
briar
a lost
patch,
cause.
and
Yeah.
go down to Florida, even though it's not where you necessarily want to be, uh, and just have a stripped down narrow obstruction case, and then uh, and then politically run on the Supreme Court's decision. Use that as part of your political campaign. That there's no other accountability to be had because of what the Supreme Court's done. So the only accountability to be had is the ballot box, and that's why everybody needs to turn out.
Well, AOC says she's going to file papers to impeach some of these justices. Did you see that today?
She's a couple of votes short.
Oh my. So,
I think
all right. Well,
she could file them, and then
yeah,
Jim Jordan and the speaker could get together and light the pages on fire alternately.
on fire. Right, exactly. They could do a Nancy and, tear them up in front of her face. That would be interesting. But they probably won't. So the Supreme Court did decide a couple other cases today that I think were of interest to the right. And this is the end of the case. And did you guys notice my tweet to John Reeves? Because he's the Supreme Court practitioner that we talk to occasionally. There were only 59 decisions this term. They didn't break 60.
I thought there were more outstanding than just 3. I actually thought they were going to go into tomorrow. I didn't know. I had the impression last Friday. Well, how many came down Friday? 5? And so
5.
there were only 8
I thought it
before
was a
Friday.
few
I
more
thought there were
left too,
10 or
but
11
apparently
besides.
there's not.
Yeah, me too. I was surprised.
I think that.
But even if there are a few more, there couldn't be more than 7. We're not going to break 70.
Yeah.
I think that's an outrage.
Yeah, I think the process, if you have this, and we've all have this because we've all read them. The historical analysis you can do is like you go back 50 years, and opinions were 8, 10, 12 pages long. Today's
Yeah.
4 opinions are 119 pages. If the court is going to continue to write, many tomes, and and everybody wants to write dissents and concurrences just so their view can be heard, there's not enough time.
Right. But that's a disservice to the nation. I really think that these 9 are not doing their jobs by not taking more cases
and disposing of them more succinctly.
Yes.
I agree with Ship. The length of all of these opinions is now over the top.
Yeah.
Somebody needs to
And if
give a seminar to the justices on
On brevity.
brevity and
you know what that is, I think that is. I'm not sure it's the justices; it's the clerks.
Maybe.
And because clerks generate the first drafts. So I don't know that it goes from 30 pages to 50 pages after the first draft because of what the judge does.
But I mean, I'm not getting more out of it than I used to get out of the cases in law school we would read, where, a good Supreme Court opinion could be 5 pages.
Yeah. For all the complaining on the left about how long this opinion took to come out, and you'd see them, it's only, the future of the country is only writing on this. You guys could get around. Like it was Sotomayor that held up that opinion.
Yeah, probably, with the length of that.
And the
thing.
fact that it was entirely responsive to the majority. Her entire opinion is responsive to the majority.
Right.
So she couldn't write it, or she certainly couldn't finish it until after the majority was done. And then how many days did she take just to finish it?
Right. So, well, the other cases they decided today that were, I think, of some interest to the right. The first one was Administrative Procedure Act case. They said the statute of limitations does not start to run until the person is affected by the regulation, not when the regulation went into effect. Which made sense to me because you could come into that industry later on after the regulation was promulgated, and it wouldn't have affected you until you actually came into the industry. So, but also I think it's good news because, anything that is slowing the administrative state down, I'm in favor of. you guys have any comment on that one?
I agree with there. A lot of the pro-administrative state people were aghast at that. I'm not sure practically what effect that has.
Yeah.
I don't
Yeah,
know.
no, it's it's going to be on the margin. It'll help a few people, but it's the government has Steve knows a lot about this. The government has consistently taken the position that the statute of limitations starts to run once they hit final on their regulations, which often is long before it actually starts to affect the people that are being regulated.
Yeah, but you've got no meaningful regulation comes out nowadays without half of an industry, you know,
Commenting on it.
commenting
Yeah.
and being right there and say, "Oh shit, we're going to hell." So it's
Yeah.
nothing is a
Yeah.
surprise anymore out of the administrative
Yeah.
state.
Yeah. Well, to small players, I think it is. It's like the one. Um, well, it was like a small business. It had to do with the fees that could be charged on credit card transactions, right? So it's just like a small mom and pop company. They're the people that really get hurt by those kind of rules. So I thought that was good, but as you say, it's not like a staggering opinion. But then the other case was the one I think the right was keeping an eye on, which is Florida and Texas had both passed statutes trying to rein in the social media companies' content moderation policies that basically are censoring speech. And so the social media companies had sued trying to overturn these statutes, saying that on their face they were violations of the First Amendment, the social media companies' First Amendment rights. And so the 11th Circuit had gone one way and the Fifth Circuit the other. Okay, so the 11th Circuit had ruled for the companies and the Fifth Circuit had ruled for the states. And the Supremes, all 9 of them, came out today and said, well, basically none of the judges who looked at this, the district court or the appellate courts, got any of the First Amendment analysis right. So a pox on all your houses. We vacate all of it and you guys can start over again and actually do the analysis right, and then we'll rule on it later.
And the issue is the term is facial
Right.
facial First Amendment,
Challenge. Right.
which means on its face, without looking around the edges and underneath, on its face, it violates the First Amendment, which is tough to do if you're,
Well, it's a very high
yeah.
standard that basically you have to prove that the statute in almost all of its applications violates the First Amendment, not just that as applied to you in your case, it violates the First Amendment. That's what lawyers call an as applied challenge. Now, you can challenge both. You can challenge a statute on its face that it violates the First Amendment. And a statute that would do that would be a statute, for example, that says you're not allowed to say, the president is a demented old senile old fool, right? You're just not allowed to say that, and that statute would on its face violate the First Amendment. um, but that's how clear it has to be, that really no application of the statute almost um, would wouldn't have a problem under the First Amendment. And that's the ground that they decided to litigate on. And that's what the court said. This is the ground you decided to litigate on. This is a very high standard. But not only that, but the courts below screwed up the analysis under that standard. So that's going to have to start over again. But second half of the opinion, um, the court takes them through, okay, carefully, this is what the analysis is in the context of the social media situation, which is, I think, why the lower courts got confused, because they're trying to apply First Amendment principles, which were not created in the social media age, to the social media situation. And so the court was trying to give them guidance so that they can actually do the analysis correct this time, and if need be, come back to the court and get an actual ruling. So, King, did you want to say anything else about that case? The name of that case, name of the first case, I think, is Moody, and this case, no, Moody's the social media censorship case.
Right. No, you've covered it.
Okay. All right. Well, we lost Ship a few minutes ago. So I think that's probably a good sign that we've had enough for today. Hopefully, we answered everyone's questions. Um, and the three of us will get together, and the Supreme Court term is obviously at an end, but there's, no end of things that we can talk about that are of right of that are of interest to the right of center in terms of legal developments. So we'll get together and figure out some other stuff we can talk about. We got Trump's sentencing coming up. There's potentially some issues in Hunter Biden's case, of course. And Fannie Willis and other things. So we will be talking to you guys later. Thanks everyone for listening. Thank you, King, as always, for participating.
I've enjoyed it. Thank you.
Okay. All right. Good night,
Good night.
everyone.